take your place there as you live, and you feed your stuff and you can go for break. Is that right? Can you Can you use your tripod?
Is that all right, Tony? Trouble watch.
Yaptın mı sen şey? Bizimkiler hiç ilgilenmiyor bununla, ben anlamadım. Ama yani temizliğin yapılacağı mahkeme de burası değil mi bu arada? Ankara'nın. Değil mi? Burası değil mi? Neresi? Eğer burası ise tam önü olmuş olur. Yoksa arkaya dönüyor.
Well, he's a bit arse. So, no.
Yandaki kameraların gölgesi geliyor o zaman. Tam çıkarsam
I think I had to go through security of it.
Tamam. Nasıl şimdi? Aslında tek önemli bir karar. Ankara Anlaşması'nda İngiltere'de iş konusu isteyen Türkiye'li girişimcileri yakından ilgilendiren bir karar. Hatırlanacağı üzere Mart ayında mahkemeye gitmişlerdi. Zira Mart ayında İngiltere Yüksek Mahkemesi gerekçeleri haklı bulsa da bir yargı müdahalesini gerektirecek düzeyde bir haksızlık olmadığını kanaat edinerek davayı reddetmişti. Bunun üzerine de Ankara Anlaşması'ndan başvuru yaparak İngiltere'de iş konusu Türkiye'li girişimciler de deniz başvurusuna gidip bu konuyu değerlendiriyorlardı ve o noktada bir noktaya gelince deniz başvurusuna gidildi ve deniz başvurusunu İngiltere Yüksek Mahkemesi'nde bir hakim incelemeye aldı ve Yargıtay üyesi gelecek anladı. Bu kararın gerekçesi olarak yapılan değişiklikleri çok sayıda Türkiye'de işin üzerinde olduğunu altını çizerek deniz başvurusuna onay verdiğini söyledi. Belli olmayan bir tarih var henüz. Daha sonra belirlenecek ne zaman görülecek davanın ama Yargıtay üyesi hakim tarafından verilen bu onay Ankara Anlaşmalar içinde yeni bir umut ışığı oldu. Zira temiz için yeşil ışığı yakmış oldu. Mahkemeler genellikle yargıçların bir yönde verdiği kararlardan sonra temiz davasını görüyorlar. Ardından da karara bağlıyorlar. Yani Ankara Anlaşması'nın ilgili olarak yeni bir hükümet mağduriyetlerine buluyordu. İşte bu nedenle de Ankara Anlaşması'nın girişimciler yargıya katılmışlardı. Bildirilmesi ve yeniden bir dava görülecek. İngiltere'de yüksek mahkemede. Geçmişi şöyle hatırlatacak olursak, Birleşik Krallık Hükümeti'nin Ankara Anlaşması kapsamında İngiltere İş Partisi'nin girişimcilerin kalıcı oturum almaları yönelik kuralları değiştirme yönünde bir adım atılmıştı. İşte bu tek tek ve Ankara Anlaşması davası şimdi yüksek mahkemede tekrardan görülecek ve Birleşik Krallık'ın durumunun ne olacağına yeniden bakacak mahkeme. Evet, bütün altın özelliklerin yeni noktalarla birlikte şöyle bir değişiklik vardı. Kişi başına 2289 lira başvurmuş. Yoldan ve bir geçmişin soru şartlarıyla getirilmiştir. Ankara Anlaşması'ndan bahsediyor yaparak İngiltere'de iş kurup burada yaşamak da şimdi yüksek mahkemeden gelecek olan karara çevrilmiş durumda. Tekrar avukatlık olursak Ankara anlaşmaların Britanya'da iş kurup burada yaşamaya başlamaları yeni görüşmelerle ilgili olarak yani burada oturum haklarının ilgili olarak Yargıtay'da yeniden bir dava görülecek ve temiz başlamadan sonra da nihai karar açıklanmış olacak. Biz de görüşmelerinde olarak aktarıyoruz.
Sessions will get underway in the next hour. You can see behind it is unprecedented. This has never happened before. Justices sitting this court. It's never been opened before for one specific case. That's what's happened here. 11 justices listen to the arguments from the government and from the members. They decided that it's going to be to decide. Then there was this Scottish possession, and they decided that in certain circumstances it was right to get involved. And not only that, they went further, and they said that they talked about the motivation of the government authorities, and that this motivation was to stymie parliament, to stymie debate ahead of this big decision. And even when we talk about the objectives of the government doing that, as a policy to pursue a no-deal Brexit without further so quite a lot of respect from the Scottish Court. So the first thing that has happened in the Supreme Court is that initial hurdle. Is it right for the courts to make a decision in this process? I was speaking to Joanna Cherry earlier, and her argument is that this isn't a business of the courts. Politics happening across the road in Parliament. It's just across the road where we are. What she's saying is that politics has broken down. They're not able to challenge the government. That's why the courts should step in. Now the government may well argue, well, actually,
In emergency, I may need you to alive because everyone's going to be, but we have done it before and never been emergency. I'm just it's called Coops and I can't go.
Have you seen James?
He's by the truck. I think I've seen.
Yeah, no, he was looking for you.
Can we go in and do it at once?
Don't just go.
No, it's not, and it's quite expensive as well. For some, it took about 6 or 7 quid. Yeah, it's a lot.
She's like, yeah, exactly.
About 7. They said about 6, about but they want me to do engine stuff. It's not going to be no engine. Yeah, it's just, there's so many of us. What engineer? I said that, he said, I might want to do a bit of Yeah, but I mean, there's enough. No, I got to walk up and over here. Yeah, stuff like that. It's like FaceTime.
You can carry it around.
Yeah, exactly. And that's it, isn't it? Yeah. You can see that in time. Visible. It's all good.
We're staring down the barrel of the gun, mate.
Yeah, we are.
That's it there.
As long as they can bypass it. Yeah, you got something else.
Tomorrow as well.
No, Thursday. You're on tomorrow. Thursday, yeah.
I'm doing
Of course, exactly. That's
doing the Brexit protest.
He doesn't want to stay.
haber? Eyvallah, sağ ol. Ne yapıyorsun? Merhaba. Eyvallah, sağ olasın. Gelmiyor musun bu tarafa? Bu şeyi yazdınız mı? Ankara Anlaşması ile ilgili bir temiz başvurusu kabul edilmiş mi? Yazdık mı? Biz buralardayız gelirsen.
rise.
Good morning, everybody. Before we start, I would like to mention a few matters. We have before us two appeals, one from England and Wales and one from Scotland. They both involve the same issue: whether it was lawful for the Prime Minister to advise Her Majesty to authorise the prorogation of Parliament by order in Council. That this is a serious and difficult question of law is amply demonstrated by the fact that 3 senior judges in Scotland have reached a different conclusion from 3 senior judges in England and Wales. The Supreme Court exists to decide such difficult questions of law, and we shall do so in accordance with our judicial oaths, to do right to all manner of people, according to the laws and usages of this realm, without fear or favour, affection or ill will. It is important to emphasise that we are not concerned with the wider political issues which form the context for this legal issue. As will be apparent when we hear the legal arguments, the determination of this legal issue will not determine when and how the United Kingdom leaves the European Union. As is usual, we shall hear arguments from each side in each appeal, first the appellants and then the respondents. We also have a small number of interventions from interested parties, including one from Northern Ireland, where the courts have not considered the prorogation issue, at least yet. For obvious reasons, these appeals have had to be heard at very short notice. We are grateful to everyone involved, the parties and their legal teams, and in particular the court staff, for their hard work in preparing for this hearing, for the written materials so promptly delivered, and for the cooperative way that everyone has worked with one another. As usual, these proceedings are being live streamed so that anybody who wishes to do so and has access to a computer can watch the arguments as they unfold. This is a very important aspect of open justice, and we hope that it will enable many people to understand what these appeals are all about, and just as importantly, what they are not about. Lord Pannick.
Morning, my ladies, my lord. May I, on behalf of all of us, thank the court and the court staff for facilitating so speedy an appeal on these important matters. The court has a list of counsel appearing in these appeals. On behalf of Mrs. Miller, I want to make a submission on what we see as the 3 main points which arise on these appeals. May I please identify these issues and then develop my submissions on each of them. The first of them is, we say on the facts that the Prime Minister advised Her Majesty to prorogue Parliament for a period as long as 5 weeks because he, the Prime Minister, wished to avoid what he saw as the risk that Parliament during that period would take action to frustrate or to damage the policies of his government. And on this first issue, we will adopt the substance of the reasoning of the inner house of the Court of Session and briefly add some further points, in particular on the relevance of the failure of the Prime Minister to produce a witness statement, either by himself or by the Cabinet Secretary, responding to the allegations as to his motive. The second matter I will seek to address is that we will say that it is elementary in public law that a power may only be exercised for a proper purpose. And we will say that that principle applies to prerogative power as it does to statutory power. We say it is an improper purpose for the Prime Minister to use the power of prorogation because he wants to avoid the risk of Parliament undermining the policies of the executive during the relevant period. And that is because under our system of constitutional law, Parliament is sovereign and the executive is accountable to Parliament. For the executive to use a prerogative power to seek to evade control by Parliament stands the basic principles of constitutional law on their head. It conflicts with the basic principle of our constitutional law, stated by Lord Brown Wilkinson. I'll take the court to the authority later, but let me give the citation. It's in the Fire Brigades Union case, Authorities Volume 3, tab 42, at page 552, E to F, and may I quote, "The constitutional history of this country is the history of the prerogative powers of the Crown being made subject to the overriding powers of the democratically elected legislature of the sovereign body." We will say that the arguments for the Prime Minister and the Advocate General assert the constitutional novelty that the powers of the democratically elected legislature are subject to the desire of the executive to avoid parliamentary scrutiny. And our third submission will be, with great respect, that the Divisional Court was wrong to conclude that the issues in this case are non-justiciable. Identifying whether a power has been used for a valid purpose is a legal question. It is not a political question. It's a question for the courts, and the rule of law so demands. This court is not being asked to identify a list of purposes for which prorogation would be lawful, nor is this court being asked to specify what would be a valid period of prorogation. The court is being asked to answer the legal question of whether it is within the scope of the power conferred on the Prime Minister for him to exercise it for the purpose alleged. My understanding is that Lord Keane, my learned friend Lord Keane, is going to address the facts of this case, and my learned friend Sir James Eadie is going to address the legal issues, that is issues 2 and 3. There may be some modification of that, but in substance that's what it amounts to. Can I also say I'm not abandoning the various other ways in which the claim has been put in the written submissions and in the points made by the interveners. And we're very grateful for all the interventions, and I have much of my submissions is derived from the points that are made in them. But I want to focus my oral submissions on what we see as the three main issues. My ladies, my lords, before I develop those 3 points, may I also indicate, by way of introduction, why we are going to say that the 3 points which are highlighted in the introduction to the written case of the Prime Minister and the Advocate General at paragraph 6 through to 9 have no substance. And they make 3 essential points. First, they say that there are no legal rules, only conventions governing the frequency with which Parliament sits and the length of time between parliamentary sessions. I emphasise we are not inviting the court to specify any such rules. Our case is that when the Prime Minister exercises his admittedly broad discretionary power to advise Her Majesty on prorogation, it is an improper purpose for him to be motivated by a wish to avoid parliamentary control over the policies of his government. The length of the prorogation in this case is important, but it is important not because a prorogation may only be for 1 week or 3 weeks. That is not our case. The length of the prorogation is relevant because the exceptional length of the prorogation in this case is strong evidence that the Prime Minister's motive was to silence Parliament for that period because he sees Parliament as an obstacle to the furtherance of his political aims. The second point emphasised by the Prime Minister and the Advocate General is that there are statutory provisions which regulate, to some extent, parliamentary sittings. Most recently, as the court will have seen, the Northern Ireland Executive Formation Act of 2019. Our response to that point is that none of that legislation addresses or affects the common law power and duty of this court to ensure that a discretionary prerogative power is not exercised for an improper motive. And the third point that the Prime Minister and the Advocate General emphasise is they say that this complaint is academic, their word, because Parliament was able to sit, and did sit, between the 3rd and the 9th of September, and Parliament will sit again on the 14th of October. They point out that Parliament legislated between the 3rd and the 9th of September, and if it wishes, it will be able to legislate again as from the 14th of October. Our answer to this point is twofold. First, we say if we can sustain our complaint that on the 28th of August, the Prime Minister advised Her Majesty that Parliament should be closed for 5 weeks because he was concerned that Parliament would or may damage the implementation of his policies, then that is an invalid purpose. And it is, with great respect, not for this court to seek to assess what Parliament would, may, or will do during those 5 weeks. If, as we contend, the Prime Minister acted for an improper motive, it is not now open to the Prime Minister to say that his fear was mistaken. But in any event, it is very far from academic that Parliament is unable to conduct such business as it thinks appropriate for the 5 weeks. To put it at its very lowest, Parliament may decide during the 5 weeks, now 4 weeks left, to enact further legislation, informed by the answers to parliamentary questions, informed by debates, informed by reports from parliamentary committees. Parliament may, I don't ask the court to say more than this, but Parliament may want to keep a close eye on the negotiations, if any, with other member states during the period. Parliament may wish to keep a close eye on planning for a no-deal exit during the 5 weeks. And in the light of parliamentary scrutiny, Parliament may wish urgently to legislate during that period. It may wish to impose further obligations on the Prime Minister in the period leading up to the EU Council meeting on the 17th and 18th of October. The issues in these proceedings are very far from academic. The Prime Minister and the Advocate General say at paragraph 77 of their written case that there is no authority which supports the proposition that the exercise of a power to prorogue the legislature is amenable to judicial review. Our response, which I will develop, is that there are many precedents establishing the relevant principles of our constitutional law. There has hitherto been no need for any court to apply those principles in the context of the prerogative power to prorogue, because no Prime Minister has abused his powers in the manner which we allege in at least the last 50 years. That is, back to the development of modern principles of judicial review.
Well, could I just raise one point there? I mean, is it right that there is no authority in this country or anywhere else as the use of judicial review to control prorogation? Because I was particularly interested in reading Anne Tromey's book called The Veiled Sceptre, which deals with prorogation in the sort of Westminster model. And it's quite clear from that the sort of issues of misuse or alleged misuse of power have come up on many occasions in many different jurisdictions.
Not in courts.
No, but that's why I was just wondering why not, given that they clearly, are we just looking at this country? Are we looking rather more broadly at experience in the common law world?
We found, and the other side have found, no judicial authority. And I'm suggesting that the reason in this country, at least, why no case has come to court is because nobody has identified any similar factual circumstance in which the principles have needed to be applied. But I do say that there are well-established authorities as to the principles that should be applied in the circumstances of such a case. My ladies, my lords, one other preliminary matter. We say that Her Majesty the Queen enjoys no personal prerogative in this context. Her Majesty was obliged to accept the advice from the Prime Minister. The Prime Minister and the Advocate General disagree on that issue. See paragraph 35 of their written case, but they add, and we agree, I quote, "This is not an issue which arises for determination on the present appeal," end of quote. It may assist the court also just if I draw attention to what happened in this case, because on the 29th of August, the Lord President of the Privy Council, Jacob Rees-Mogg, was one of the Privy Councillors who attended on Her Majesty at Balmoral, and he has described how Her Majesty formally approved the Prime Minister's request to prorogue Parliament. And if the court, please, has the trial bundle in the Miller case, the court will see at tab number 51.
Do we have this electronically?
Yes, it's page 373. I hope the court also has it electronically.
Well, we have no less than, I'm sorry about this, but there's always trouble with the documents in these cases, and we need to sort it out. We've got 5 different documents on a memory stick. Is it the hearing bundle?
Yes, it's called the trial bundle for hearing on 5th of September. I hope that is the same document as the President is referring to. It has 68 tabs, maybe more than 60.
How many pages has it got? Oh, yes.
My volume goes up to page 518.
Well, mine goes up to 591.
As does mine, I'm afraid.
So, I think it's could I ask the court to turn to tab number 51, which is page 373.
Let's see whether it works, yes. 373.
Yes, that should be an interview on the Today programme, and it was an interview, Mr. John Humphreys interviewing Jacob Rees-Mogg.
I'm afraid not.
It isn't.
Well, then it's a different bundle.
No, I think it may be the same bundle, but it's a different page.
I'm very sorry about this.
No, but it's not your. Of course, it's not the President's fault. Does the court have tab 51?
I do, but nothing happens when I press on it. Put it on paper.
I'm terribly sorry, but it may be that we try to sort that out and we use paper for the moment.
It's page 436, I think, but nothing happens.
I'm very grateful.
Nothing
happens.
Yes. 436.
Yes.
Does the President have that number?
Yes.
That page? I'm grateful.
Yes.
Well, I don't know why the numbering is different, and I'm very sorry, and it's very inconvenient for everybody, in particular the court. But if we turn over to the second page of that document, which I have at 374, at the end of that page, Mr. Jacob Rees-Mogg explains that it's simply wrong. The Queen, Her Majesty, had no discretion over this. There is no precedent for the Queen refusing a request by her Prime Minister under these circumstances. This is a straightforward decision by the Prime Minister giving formal advice to the Sovereign, which a constitutional monarch is obliged to follow. And on the next page, for those of the members of the court using the paper volume, it's page 375. At the bottom of that page, Mr. Humphreys, and the same when you said the Prime Minister wishes to prorogue, etc., she would just say approved. Mr. Jacob Rees-Mogg, that's absolutely right. It's important that people understand this is a prime ministerial decision. It's not a decision of the Sovereign and hasn't been, etc., etc. So that's what happened in practice. Her Majesty was advised that it was a matter for the Prime Minister, but as I've indicated, nothing turns on this, but it's the reason why we, for our part, are making no criticism of Her Majesty in these proceedings. Her Majesty acted on the advice of her Prime Minister. That's what I wanted to say, my lady, as by way of introduction. Can I turn to the first main issue, and that is the facts of this case. And I can be brief on this subject because we agree with the analysis by the Inner House of the Court of Session, in particular Lord Brodie at paragraph 89 and Lord Drummond-Young at paragraphs 120 to 123. And the essence of their reasoning is that the Prime Minister had made clear that he is determined that this country will leave the EU on the 31st of October, deal or no deal. The Prime Minister does not have a majority in the House of Commons for a policy of leaving, if necessary, with no deal. The Prime Minister has given no sensible reason, indeed no reason at all, for the exceptionally long period of this prorogation. And the Prime Minister, as the evidence shows, sees Parliament as a threat to the fulfilment of his policy. I want to emphasise 2 points, if I may, additional to those made by the Inner House. The first is that there is evidence in the form of statements by the Prime Minister himself, which shows that the Prime Minister regards Parliament as at least a potential threat to the implementation of his policies. And there are 2 interviews with the Prime Minister. The first is by Sky News, and the court will find that interview in the same trial bundle. I have it at tab 54, which is page 400. I hope the court will be able to tell me where electronically the court has it, but in my bundle, it's trial bundle tab number 54, page 400. And it's an interview, a Sky News interview with Boris Johnson by the journalist Sam Coates. And if the court, please, would turn to the transcript, at the top of the page, Mr. Coates asked the question, when people voted for Brexit, they were voting for Parliament to take back control, but now you, as Prime Minister, are trying to limit the ways that Parliament can express its view because you disagree with them, etc., etc. And Mr. Johnson then responds, and the court will want to read all of this, but can I highlight at the bottom of the page, the final paragraph? The Prime Minister says this: just to get back to Parliament, which I bet you are going to ask me about, just to get back to Parliament, I am afraid that the more our friends and partners think at the back of their minds that Brexit could be stopped, that the UK could be kept in by Parliament, the less likely they are to give us the deal that we need. And so that is why I really hope that MPs will allow the UK to do a deal, get ready for a no-deal Brexit, and that is the best way forward for our country, believe me. This was immediately after prorogation. This is the 30th of August, 2019. And to
the electronic number, Lord Panic, is 464.
Yes.
Very grateful. I'm terribly sorry about this.
That means it's 63 pages on from the number you have.
Yes, well, I'm sorry.
I feel sure somebody can help you.
I'm sure.
Very well. So I had 63. Well, then the next...
mental arithmetic is up to it, I'm sure.
It may test my abilities, but the next number, the next page that is relevant, I have at tab 55. I have at page 408. And adding 63 to that takes us to 471. And this is a BBC report, page 408 or page 471.
Yep.
On the second page of that, 409, the third paragraph up from the bottom, we see that Mr. Johnson was speaking to the BBC. And on the final page, not the final, penultimate page of this document, 473, about a third of the way down the page, there's a paragraph, he said, and that's Mr. Johnson, the best way to leave with a deal is if our friends and partners over the channel don't think that Brexit can be somehow blocked by Parliament. As long as they think in the EU that Parliament might try to block Brexit or might even succeed in blocking Brexit, the less likely they are to give us the deal we want. Now, I'm of course not asking this court to say whether the Prime Minister's assessment is correct or is incorrect. The relevance of these statements is that they are strong evidence to be added to the material referred to by the Inner House as to the Prime Minister's motive in deciding to close Parliament for 5 weeks during this negotiating period. The other point I want to make on the facts is that it is, we say, a remarkable feature of these proceedings that the Prime Minister has not made a witness statement explaining why he decided to advise Her Majesty to prorogue Parliament for a period as long as 5 weeks. And that is even though we made very clear in commencing these proceedings that an important part of our case is that the Prime Minister's advice to Her Majesty was motivated, or at least strongly influenced, by the Prime Minister's desire to prevent the risk, as he saw it, of Parliament damaging government policy. And we set that out in our statement of facts and grounds, dated the 28th of August, which is in the trial bundle at tab 2. If the Prime Minister did not wish personally to make a witness statement, such a statement could have been made by the Cabinet Secretary, as in the GCHQ case. The only witness statement from the government side is from the Treasury Solicitor, whose statement is confined to the production of documents. The Treasury Solicitor, Mr. Jonathan Jones, could not give evidence as to the Prime Minister's reasons for advising a 5-week prorogation. My ladies and my lords, of course, the production of a witness statement from the Prime Minister, or indeed anyone else, setting out the reasons for advising on a prorogation as long as 5 weeks would have had legal consequences. And the legal consequences of such a witness statement would have been almost inevitably an application to cross-examine. The legal consequences would also be that it would be a contempt of court, of course, for such a witness statement not to tell the truth. Our submission is that the documents pose more questions than they answer, as the Inner House has pointed out. And in any event, the production of those documents is no substitute for evidence from the Prime Minister or from someone on his behalf stating to the court in terms why he thought a prorogation for the exceptionally long period of 5 weeks was appropriate. We draw attention to the decision of the Court of Appeal in the Das case. Now, this appears, I hope, in the supplementary authorities bundle, supplemental authorities bundle at tab number 19. It's volume 1 of the supplemental authorities bundle, volume 1.
Yes.
I hope it's at tab 19. It does not have, I'm afraid, a page number.
Well, it's 292 on the supplemental authorities.
I'm grateful. I'm grateful.
I mean, I've got several supplemental authorities.
Supplemental authorities, volume 1, tab 19, Queen on the application of Das against the Home Secretary.
Yes.
Supplemental bundle.
And the relevance of this case is that it approves the test stated at first instance by my Lord Justice Sales, sitting at first instance in that case, as to the applicable test relevant to this principle that I am relying upon. And that appears in DAS using the numbering in the report right at the end, page 3565. If I may...
I'm afraid some of us are struggling here. I've got a supplemental authorities bundle produced by your solicitors.
Yes.
That goes up to tab 12.
Oh dear.
I've got a supplemental authorities bundle 2 produced by your solicitors, which starts at 35.
Then,
but you want one in the middle.
I do, my Lord. I'm terribly sorry. Maybe the best thing to do is if we hand up to those members of the court who, and I anticipate from the signs I'm receiving that my Lord the Deputy President is in the same position. I don't know whether, and so we need a number of copies, please, urgently, of the DAS authority. Can we just have DAS? Can we just have tab number 19? I'm terribly sorry about this.
I've got it.
What page?
35. It's within the report, 3565.
With the assistance of the...
We don't have electronic pages. Tab 19 of the supplementary authorities bundle. The updated supplemental authorities bundle.
Sorry, they're just coming here.
You've got the updated supplemental authorities? Should be updated.
Take it to the President first.
It's in the what? 1481 in the cherry bundle. Yes, it's also in the in the bundles authority in the cherry.
1481.
Ah, yes. Number 13. Yes, I have that.
In the cherry volume, it also appears at authorities, volume 1, tab 13.
Yes.
Great. And the page number is...
Lord Panic, it does appear that there was initially produced supplementary authorities bundle.
Yes.
Then it was enlarged.
Yes.
Then there came number 2. And you've got to decide whether we all need to have, for the purposes of this appeal, the enlarged bundle.
Well,
and if so, as soon as possible.
Well, indeed, my Lord. Absolutely.
But if you can actually use the Scottish...
well, I can for this case. Yes, I can for this case.
That may be enough.
Yeah. But it is for DAS. I'll have to check whether there are other authorities that the court needs to look at and doesn't have. Tab number 19 in the Miller case, 13 in the Cherry case, is the DAS authority, and it's at page 3565. It's paragraph 80. And counsel for the Secretary of State is submitting that there's no obligation to file witness evidence. She urged the court not to punish the Secretary of State for not filing evidence. She referred to the scarcity of resources, heavy litigation burden on the Secretary of State, the need to prioritise resources on those currently detained, none of which factors are relied on, of course, in the present case. And the Court of Appeal, this is Lord Justice Beatson, then approves the statement at first instance by the judge, my Lord Sales. He observed, where a Secretary of State fails to put before the court witness statements to explain the decision-making process and the reasoning underlying a decision, they take a substantial risk. In general litigation, where a party elects not to call available witnesses to give evidence on a relevant matter, the court may draw inferences of fact against that party. The basis for drawing adverse inferences of fact against the Secretary of State in judicial review proceedings will be particularly strong, because in such proceedings the Secretary of State is subject to the stringent and well-known obligation owed to the court by a public authority facing a challenge to its decision. In the words of Lord Walker for the board in the Belize case, to cooperate and to make candid disclosure by way of affidavit of the relevant facts and, so far as they're not apparent from contemporaneous documents which have been disclosed, the reasoning behind the decision challenged in the judicial review proceedings. And we rely on that statement of principle. We say that at best from the Prime Minister's point of view, the documentary material, that is the material referred to by the Inner House and the statements to broadcasters to which I have referred, are at best from the Prime Minister's view ambiguous about whether his concern about Parliament potentially damaging negotiations was his motive, or an important part of his motive, for advising on an exceptionally long prorogation. We say this case cries out for an answer in a witness statement to the allegation that was made against the Prime Minister. And in the absence of such a witness statement and the willingness of the Prime Minister to submit to potential cross-examination, we say the court should infer that there is no answer.
You might want to check. I think this question about drawing inferences in the absence of reasons is considered in Padfield.
Yes, it is. It is. I'm going to come to Padfield.
Oh, right.
Your Lordship's, of course, correct. There are many cases where this point has been addressed. I was also going to mention the GCHQ case, where, of course, issues were raised about national security, whether or not the decision of the then Prime Minister to remove the right to trade union representation at GCHQ without consultation because of national security considerations was the subject of witness evidence. It was the subject of an affidavit from the Cabinet Secretary, and the appellate committee in that case, notwithstanding the very sensitive subject matter, made it very clear that the government needed to produce evidence to support their claim that there were national security considerations. Sir Robert Armstrong produced an affidavit. Can we look, please?
Can I just, it may not matter, but I think Lord Walker was dissenting, wasn't he, in the Belize Alliance case? And, I mean, you said for the board, I think he was dissenting. I don't know whether that statement, which is very clear and helpful, has been adopted either by this House, by this court, or by the board.
Well, we can check that. It's certainly been accepted as the judgment of my Lord Sales indicates, approved by the Court of Appeal in that case as the governing principle, certainly in the context of public law, that if an allegation is made, a factual allegation, and the material is at least ambiguous, one expects the minister or someone on his behalf to answer that.
No, I mean, I'm not questioning the principle. I just think it'd be clear, useful to have a most authoritative statement of that.
Can we look, see if we can find that? It may be that there isn't, otherwise my Lord Sales would have referred to some approval, I'm sure, of the principle stated by Lord Walker. But we say that that is the principle. Can I show the court, please, the GCHQ case? That is in the Miller Bundle of Authorities, Volume 1, and it appears at tab number 11. very familiar case, of course. The relevant passages that we rely upon, first Lord Scarman at page 404, picking it up at page 404, letter E, just under letter E.
Do you know the electronic number of that, or again, are you not unable to help us?
Yes, well, it has Authorities Bundle Miller, Volume 1, and it's at tab 11.
It's 31.
It's page 31 of the 51 pages, yes.
And if the court turns using the internal numbering at page 404, internal numbering, because I'm afraid I don't have the electronic numbering, page 404, just under letter E, Lord Scarman says the point of principle in the appeal is as to the duty of the court when in proceedings properly brought before it, a question arises as to what is required in the interests of national security. And then picking it up again at G, though there are limits dictated by law and common sense, which the court must observe in dealing with the question, the court does not abdicate its judicial function. If the question arises as a matter of fact, the court requires evidence to be given. If it arises as a factor to be considered in reviewing the exercise of discretionary power, evidence is also needed so the court may determine whether it should intervene to correct excess or abuse of the power. And on the preceding page, page 403, just under letter B, the court sees that there was evidence. There was evidence from Sir Robert Armstrong, the then Cabinet Secretary, who addressed the relevant issue of facts. And at page 420 of the report, at letter E, Lord Roskill is to like effect, 420 letter E, the courts have long shown themselves sensitive to the assertion by the executive that considerations of national security must preclude judicial investigation of a particular individual grievance. But even in that field, the courts will not act on a mere assertion that questions of national security were involved. Evidence is required that the decision under challenge was in fact founded on those grounds. That principle exists is, I think, said Lord Roskill, beyond doubt. And then he goes on to the merits of the matter. So we respectfully submit that on the facts of this case, the Inner House was correct in its analysis and conclusion as to the motive of the Prime Minister. Their conclusions, we say, are supported by the Prime Minister's own public statements as to his concerns as to what Parliament may do, and the court, in addition, should be prepared in the circumstances of this case to draw an inference from the absence of any evidence on the government side by way of witness statement as to the answers to the allegation from the Prime Minister, or indeed from the Cabinet Secretary on his behalf. We submit that on all the material, the court should conclude that but for the Prime Minister's wish to avoid parliamentary control, he would not have recommended to Her Majesty a prorogation for a period as long as 5 weeks. But he would have recommended a substantially shorter period in order to allow for a Queen's speech, the closing of one session, the opening of another, as had occurred on every occasion that is a shorter prorogation, on every occasion in the last 40 years. If the court accepts our submission that there was here an improper motive, it is for the Prime Minister to satisfy the court that it was not material to the decision that he took, and he can't do that in the absence of any affidavit or witness statement. That's what I want to say in answer to the first part of the case. Lord Keane, of course, will respond for the government by way of answer to the decision of the Court of Session, and my friend Mr. O'Neill will have the opportunity to address the points that Lord Keane made. But that's what I want to say in opening on that part of the case. Can I turn to the law? The second part of my submissions concerns our contention that for the Prime Minister to advise Her Majesty to prorogue Parliament for a period of 5 weeks in order to avoid what he saw as the risk of Parliament undermining his negotiations is to use the prerogative power for an improper purpose. And we say it's well established in public law that a power conferred on the executive may only validly be used if it is for a proper purpose.
Excuse me, for my apologies.
Thank you. No, not at all, thank you. And this is a principle which can be traced back to the 17th century and traced back in modern times to Padfield. The matter is addressed by the learned authors of De Smith, which I hope the court will find in supplementary authorities at tab 16, although that too may not...
De Smith's Judicial Review.
Smith's Judicial Review. De Smith.
Yes.
Judicial Review, tab 16 of Supplementary Authorities, Volume 1.
I think this supplemental authorities bundle is entitled Updated Supplemental Authorities.
Grateful.
It is electronically, at least.
Page 193, anyway.
Yes.
There is apparently, I'm told, an envelope that some members of the court may have with the updates. That may be the answer.
Yes, because I had DAS, but I'd opened the envelope, so possibly that's the explanation.
I appreciate some members of the court may not have appreciated that there are We'll sort this out over the short adjournment, but I hope that members of the court will have the updated material. It's tab number 16 of the Supplementary Authorities, Volume 1. Yes. I'm grateful. That's the answer. It's probably not the most difficult question in this case, but it's the answer to that question. Supplementary.
But well spotted by the young lady behind you.
Indeed, I'm very grateful to Emily from Mishkons. The court will see at paragraph 5009, which is the second page of this insert, that the learned authors, who of course are Lord Wolfe, Professor Jow, Catherine Donnelly, Ivan Hare, they describe the origins of this principle back to the 16th century, and the court will no doubt wish to look at that. But at 5-018, we come to modern times, and we come to the decision in 1968 of the House of Lords in Padfield was an important landmark. And it reminds us of the context. The minister had refused to appoint a committee, as he was statutorily empowered to do at his discretion, to investigate complaints made by members of the Milk Marketing Board that the majority of the board had fixed milk prices in a way that was unduly favourable to the complainants. The House of Lords held that the minister's discretion was not unfettered and that the reasons he'd given for his refusal showed that he'd acted ultra vires by taking into account factors that were legally irrelevant and by using his power in a way calculated to frustrate the policy of the Act. And we have Padfield in the same volume, tab 18.
But I mean, this is a statutory.
Yes, it is.
Yes.
I have to satisfy the court that the same principle applies in the context of a prerogative power.
Yes, I mean, we may not need to look at Padfield for the statute.
Well, it sets out the basic principle. Can I very briefly just identify what the basic principle is? And it's Lord Reid at page 1030, between C and D, very familiar. Parliament must have conferred the discretion with the intention that it should be used to promote the policy and objects of the Act, and they must be determined by construing the Act as a whole. Construction is always a matter of law for the court. If the minister, by reason of having misconstrued the Act or for any other reason, so uses his discretion as to thwart or run counter to the policy and objects of the Act, our law would be very defective if persons aggrieved were not entitled to the protection of the court, so it is necessary first to construe the Act. And then over the page, at page 1032, is the point that my Lord Deputy President was averting to. At the bottom of 1032, it was argued that the Minister is not bound to give any reasons for refusing to refer a complaint to the committee, that if he gives no reasons, his decision cannot be questioned. And it would be very unfortunate if giving reasons were to put him in a worse position. But I do not agree, says Lord Reid, that a decision cannot be questioned if no reasons are given. If it is the minister's duty not to act so as to frustrate the policy and objects of the Act, and if it were to appear from all the circumstances of the case that that has been the effect of the minister's refusal, then it appears to Lord Reid that the court must be entitled to act. And then I emphasise the following sentence. A number of authorities were cited in the course of the argument, but none appeared to Lord Reid to be at all close to the present case. In other words, his lordship was not deterred by the absence of a clear precedent. His lordship proceeded, as I am inviting this court to proceed, by reference to principle. The speeches of the other members of the appellate committee were to like effect, and without taking the court through them, they were Lord Hodson in particular at 1049 E to G, Lord Pearce at 1053G to 1054A, and Lord Upjohn at 1061E to 1062A.
It might be said that there is a different nuance here from the passage that you cited from Mr. Justice Sales, that rather than drawing an analogy with a failure in ordinary proceedings to lead an available witness, and therefore being inclined to draw an adverse inference against a party, it's put here more in terms of looking at all the circumstances and deciding what inference should reasonably be drawn.
Yes, but in my submission, the absence of a witness statement that addresses what is otherwise at least a strong prima facie case is a relevant consideration for the court to address. Public law has moved on in my submission since 1968. The approach in 1968 was that the minister cannot simply say, I have no duty to give reasons. The modern law is strongly influenced by the development of duties of disclosure and a recognition that a minister can be expected specifically by evidence to address a complaint. But I recognise this case is not of itself authority.
But it's also interesting, isn't it, that Lord Reid was speaking of if it were to appear from all the circumstances of the case that that had been the effect of the minister's refusal to do what he should have done.
Yes, indeed. One looks at the consequences of what is happening. It's the purpose and the effect are both relevant in this context, and if the inevitable effect is to frustrate the operation of parliamentary procedures, that assists in identifying the motive of the minister.
But might it be unlawful if the effect was to do that, even if that was not determined to be the motive?
Well, that is our alternative way of putting the case, that we have put the case at all stages by reference to the motive of the Prime Minister and by reference to the inevitable effect that the Prime Minister's decision to close Parliament for 5 weeks inevitably, in the context of this case, has a very damaging impact on the ability of the legislature to scrutinise the actions of the executive. Indeed so. And we are not wedded to a solution that involves a finding of a wrongful motive. We have put the case in both ways.
The gravamen of your complaint is really the effect on parliamentary accountability, parliamentary scrutiny, yes, the opportunity to legislate. Yes. And even if there had been no intention to block all that in order to pursue a particular government policy, you would still have the same complaint, would you not? Well, at least a stronger complaint, albeit you'd be putting it in a different way.
Well, one can put it either way. At its very lowest, the Prime Minister's decision to prorogue for a period as long as 5 weeks prevents Parliament from performing its scrutiny functions over the activities of the legislature. It means Parliament cannot legislate and it cannot inform itself for the purposes of legislating by the asking of parliamentary questions, by holding parliamentary debates, by the reports of parliamentary committees, all at a time when we say it is self-evident that Parliament will or may wish to carry out such activities.
Do we have evidence about questions being put and not being answered as a result of the prorogation?
Well, as a matter of principle, questions cannot be put. Once Parliament is prorogued, it is simply not possible for parliamentary questions, written or oral, to be tabled.
But were any tabled and not answered?
The questions that were asked before prorogation, I suspect they were, but we don't have the material. I can seek to find out the answer to your ladyship's question. But as a matter of principle, any development, and there are inevitably developments, as from the 9th of September, cannot lead to any parliamentary question being asked, written or oral, by any member of Parliament. Parliament is closed. You cannot, as a member of Parliament, member of the Commons, member of the Lords, you cannot ask any question. And that is made clear in the material before the court. It's made clear, if the court wants to have document in the briefing paper from the House of Commons, which is in the main bundle at the hearing bundle, trial bundle, tab 29. It's the House of Commons briefing paper. It's page 169, and adding, was it 63 pages, takes us to 232. But I have it at tab number 29 of the trial bundle. And the relevant passage, if the court has that document, is at page 180 in the paper version, 223 in the electronic version. In the middle of the page, neither House of Parliament sits. During prorogation, Parliament does not meet. This means legislation cannot be considered or introduced by MPs and peers. Debates in the Chamber or Westminster Hall are not held. Written and oral parliamentary questions cannot be asked. Committees do not carry out the usual business of inquiries and evidence taking. The temporary suspension of activity is not normally significant, as a new session typically begins shortly thereafter. For a longer prorogation, however, this suspension of activity weakens the ability of parliamentarians to hold the government to account. That's the undisputed position. There will inevitably, thinking about your ladyship's question, there will inevitably have been parliamentary questions that were pending on the 9th of September, which will not have been answered and will not now be answered until the 14th of October. But the point I emphasise is that Parliament is prevented from responding to whatever developments there may be, and it's not difficult to see that there are and will be developments as from the 9th of September.
Do we have evidence of what other business was lost? I mean, there were a number of bills.
Yes, there were.
Is there evidence about that?
We can try to find that for the court. Some of those bills, I accept, will be reintroduced once Parliament resumes.
So that's not an aspect you rely on particularly?
Well, it's not in the forefront of my submissions. The forefront of my submissions is that in the circumstances of this case, we say the plain effect of the Prime Minister's decision that Parliament will not sit for 5 weeks is to prevent Parliament from performing its scrutiny functions, which include legislation, in response to whatever developments there are not.
But an important part of this case is the distinction between Parliament adjourning, going into recess,
yes,
and prorogation.
Absolutely.
And an important feature of prorogation is that in most circumstances, bills that are currently under
yes,
consideration are lost.
Precisely so.
And it would be of great interest to us to know which bills were lost.
We can find out. We will find out the answer to the question put by the President, by my Lord Carnworth. Of course, during a recess, by contrast with prorogation, parliamentary questions can be asked and they are answered. During a recess, parliamentary committees continue. They produce their reports. And of course, a recess is a judgment made by Parliament itself. Parliament decides when it is going to recess. There's a need for a motion before the House. So just finishing this submission, Padfield, the authors in De Smith, and I was showing the court the relevant passage in De Smith, they make the point in supplementary authorities, it was tab 16, they make the point at paragraph 5090.
90 or 19?
90, 5090.
Thank you.
That this is an elementary proposition. That is, that power granted for one purpose may not be exercised for a different purpose. It's elementary, and it is elementary.
But do they deal with the question of the prerogative as opposed to the in this context?
Smith, not that I'm aware of. I will check, but no, we haven't found such a statement. Now, in the context of a statutory power, identifying the proper purpose for which the power may be used is, as Lord Reid said, a matter of construing the legislation, assisted, of course, by legal principles which the court applies. In the context of a prerogative power, the exercise is more complex because there is no statute. But we say it's not different in principle. It's still for the court to identify what are the purposes, what are the impermissible purposes for which the power may be exercised. And this has been the subject of analysis by Professor Mark Elliott. And can I invite the court's attention, please, again to the supplementary authorities. And it's at tab number 15 of the supplementary authorities. And it's the analysis by Professor Mark Elliott, published on the 12th of September, relating to this case. And it's in the light of the judgment of the Divisional Court. And if the court, please, goes to the second page of this document, in the first new paragraph, Professor Elliott has dealt with justiciability, to which I'm going to come. And he says, once the starting point is clearly established, other crucial matters follow. First and importantly, is the widely recognised principle that no government legal power is unfettered. All legal powers held by the government are legally finite, and their boundaries are determined, among other things, by reference to the purposes for which they may and may not legitimately be used. There is no good reason why this should not apply in the case of the prorogation power, and the government's ancillary authority to advise the Queen as to its exercise. It follows that those powers are legally limited, among other things, by reference to the purposes for which they may and may not legitimately be used. What those purposes are is a legal question for determination by courts in the ordinary way. When such questions arise in respect of statutory powers, they are resolved first and foremost by means of statutory construction. That is, the legislative text is examined and construed by the court, and the purposes for which the power can and cannot lawfully be used are thus determined. However, the process of statutory construction is rarely a purely literal one that entails recourse to nothing more than a dictionary, and it frequently involves the attribution of meaning to the statutory text by reference to broader, relevant, legal, including constitutional principles. And he says that this is so well established that authority is not needed, but he cites the Robinson case, which is Authorities, Volume 4, tab 46, the Sims case, Volume 3, tab 44, and the Fire Brigades Union case, Volume 3, tab 42. He then says, in the next paragraph, in the case of prerogative powers, there is plainly no formal textual starting point, such as there is when statutory powers are in play. It follows that it may be more difficult to determine the boundaries of such powers, including by reference to the purposes for which they can and cannot lawfully be used. It does not, however, follow that no such boundaries exist, nor does it follow that questions as to the location of such boundaries are anything other than legal questions. Just as fundamental constitutional principle may cast light on the proper meaning of statutory texts, and thus on questions as to the proper and improper use of statutory powers, so fundamental principle may illuminate and determine the boundaries of prerogative power, including the purposes to which they can and cannot lawfully be put. And on the next page, in the paragraph, the new paragraph, a third of the way down, In these cases, the question is therefore whether the use to which the power has been put results in the boundaries of the power having been exceeded, with reference to any purposes for which the power may not lawfully be exercised. The Divisional Court rightly noted that there are several purposes for which the power can lawfully be exercised, but the question here is whether the power has been used for a purpose for which it cannot be so exercised, and that raises questions of evidence and legal principle. He says he takes no position on the evidential question. Two legal questions then arise. Is the stymieing of Parliament, that's the inner sessions, the inner houses phrase, is it a purpose for which the prorogation power can lawfully be exercised, and is dealing with this matter something that the court can legitimately do, or are the issues non-justiciable? He says, notwithstanding all of the sound and fury, neither of those questions, it seems to him, raise especially controversial or difficult legal or constitutional questions. The first question falls to be answered by reference to fundamental constitutional principle, and one such principle is the representative nature of democracy in the UK and institutional arrangements, including executive accountability to Parliament, that are thereby necessitated. Recourse to such principle in determining the limits of the power should hardly be a controversial step, nor should the conclusion that it is incompatible with the nature of parliamentary democracy for the executive to have a legally unfettered power to suspend the operation of Parliament to shield the executive from parliamentary scrutiny. And that's our case. We say...
But I mean, it doesn't... Interesting enough, even someone as knowledgeable on this subject, Professor Elliott, doesn't have any authority to support what he says. He just says it.
No, he says it's constitutional principle. His argument is that just as a statutory power...
Yes, I mean, I understand the argument, but it would be comforting to have some authority. Yeah. I mean, the only case where I think we did have to consider this was Sanderford.
Well, we'll come to we'll come to that. But the difficulty is to the absence of occasions in which prerogative powers have been used with the purpose or with the inevitable effect of undermining a basic constitutional principle, that is here parliamentary sovereignty. It has not occurred. And just as in the Padfield case, Lord Reid said his lordship was not deterred by the absence of a precise precedent, my submission to this court is that it should not be deterred. It should apply fundamental principle. And there are two. The fundamental principle that no power enjoyed by the executive may be used with the purpose or with the effect of undermining fundamental principles of law. And the second limb of the argument is that it does undermine, either as a matter of purpose or as a matter of inevitable effect, a fundamental principle of our constitutional law, which is that the executive is answerable to Parliament. And here, the purpose and or effect of the decision is to remove such accountability, such scrutiny, at a vital time. It's not just Professor Elliott who makes these points. The other leading, I would submit, academic authority of relevance in this area is Professor Craig of Oxford University, and his analysis is in the same bundle, tab 13. Could I invite the court's attention, please, to tab 13, Professor Paul Craig, Professor of English Law at Oxford University. And I commend all of this to the court, but can I just emphasise at tab 13, the second page, in the middle of the page, and there's a paragraph in the middle. He's dealing with the argument of the divisional court. He says, if we accept such an argument, then we recast the boundaries of parliamentary sovereignty as traditionally conceived. Parliament remains omnipotent in the sense that there are no bounds to its legislative authority, but the executive can determine when Parliament exercises that legislative authority. It can choose to prorogue Parliament whenever it wishes, including in order to prevent Parliament exercising its voice through legislation or otherwise, merely because the executive believes that what Parliament might do is undesirable. The executive's decision in this respect is legally unchallengeable, irrespective of the ground on which the prorogation decision is based. If this represents the law, says Professor Craig, then every textbook, article and essay on constitutional law has missed this crucial qualification to the sovereignty of Parliament. So Professor Craig puts it the other way round. He says that if it were really to be the constitutional law of this country, that the executive may act for the purpose or with the inevitable effect of silencing parliamentary scrutiny, then one would expect to find some authority to support that contention, and there is none. We therefore submit both, as I say, that it's a basic principle of law that public powers may only be validly exercised where they are not intended, do not have the effect of undermining constitutional principle. And we say here that either the purpose of the Prime Minister or the inevitable effect of his decision is to silence Parliament unnecessarily, because it doesn't need to close for 5 weeks in order for there to be a Queen's speech, and undermine constitutional principle. What is the principle? Well, it's a principle of common law as to parliamentary sovereignty. Can I take the court, please, to the first Miller case, which is in Authorities Bundle number 3. And it's at tab number 29. Main Authorities Bundle for Miller. Bundle 3, tab number 29. I take the court first to the judgment of the Divisional Court. That, of course, was Lord Thomas, Chief Justice, Sir Terence Etherton, Master of the Rolls, and my Lord Sales. And the relevant passage is at page 73 of the report, at paragraph 18. The UK does not have a constitution to be found entirely in a written document. This does not mean that there is an absence of a constitution or constitutional law. On the contrary, the UK has its own form of constitutional law as recognised in each of the jurisdictions of the 4 constituent nations. Some of it is written in the form of statutes which have particular constitutional importance. Some of it is reflected in fundamental rules of law, I emphasise of law, recognised by both Parliament and the courts. There are established and well-recognised legal rules which govern the exercise of public power and which distribute decision-making authority between different entities in the state and define the extent of their respective powers. The UK is a constitutional democracy framed by legal rules and subject to the rule of law. The courts have a constitutional duty fundamental to the rule of law in a democratic state to enforce rules of constitutional law in the same way as the courts enforce other laws. And in this court, at paragraph 45, which is on page 138, at the bottom of page 138, paragraph 45, we're told the Crown's administrative powers are now exercised by the executive, that is, by ministers who are answerable to the UK Parliament. However, consistently with the principles established in the 17th century, the exercise of those powers must be compatible with legislation and the common law. The court added at paragraph 90, which is on page 152, just above letter C, bearing in mind this unique history and the constitutional principle of parliamentary sovereignty, it seems most improbable that those two parties, that's Parliament and the courts, had the intention or expectation that ministers, constitutionally the junior partner in that exercise, could subsequently remove the graft without formal appropriate sanction from the constitutionally senior partner in that exercise, Parliament. Ministers are constitutionally the junior partner. And the real issue in this case is whether the junior partner may lawfully remove the scrutiny of its activities by the senior partner, either with the motive or having the effect of removing such scrutiny on vitally important questions. There is, of course, a good constitutional law reason why ministers are the junior partner and Parliament is the senior partner. And that is explained by Lord Hoffman for the board, for the majority of the board, in the Banku case, which appears in Authorities Volume number 2 at tab number 23. This was the Chagos Islands case, which is very familiar to the court, and the relevant passage in Banku, it's volume 2 of the Authorities volume for Miller, tab number 23. The relevant passage is paragraph 35, which appears at page 482. Paragraph 35, page 482, Lord Hoffman, for the majority of the board, the fact that orders in council resemble acts of parliament does not mean they share all their characteristics. And then this, the principle of the sovereignty of parliament, as it has been developed by the courts over the past 350 years, is founded upon the unique authority parliament derives from its representative character. An exercise of the prerogative lacks this quality. Although it may be legislative in character, it is still an exercise of power by the executive alone. And that's why the executive is, to use this court's phrase, the junior partner in the constitutional exercise. One other authority to like effect, which I mentioned in opening, is the Fire Brigade Union case. It's to be found in volume 3 of the Miller Authorities at tab number 42. Volume 3, tab number 42. And the relevant passage is at page 552. In the speech of Lord Brown-Wilkinson, it's just under letter E on page 552. The constitutional history of this country is the history of the prerogative powers of the Crown being made subject to the overriding powers of the democratically elected, and I emphasise those words, democratically elected legislature as the sovereign body. And it is our submission that the case for the Crown in the present proceedings necessarily has to contend for the reverse, that the powers of the democratically elected legislature as the sovereign body are subject to the decisions of the executive as to when the executive enjoys, it is said, a discretion, complete discretion, to remove the powers of the democratically elected legislature in terms of motive or effect. And that was, in substance, the reasoning on this issue of law by the Inner House, Lord Drummond Young at paragraph 99. I won't take the court to it, but we draw attention to it, that the ministers cannot exercise prerogative powers with the intention or the effect of removing the powers of the legislature. Many of the cases, of course, relate to parliamentary sovereignty in the sense that the executive cannot defy or cannot frustrate what Parliament has said. The case of proclamations in 1611, which is Authorities, Volume 1, Tab 10, which we invite the court to look at, not least because Lord Coke, like Lord Reid in 1968, was not deterred by the argument there is no authority for this. Lord Coke, like Lord Reid in 1968, resolved the question by reference to fundamental principle. The argument was, leave it to the king. More recently, of course, there's the Fire Brigades Union case that the Home Secretary could not frustrate parliamentary sovereignty. But parliamentary sovereignty has also been used as the basis for other decisions by the courts. It's been used as the basis for a recognition of parliamentary privilege. In the Picken case, again, I don't have time to go to it, but it's Authorities, Volume 2, Tab 19. And parliamentary supremacy was also relied upon by my Lord the Deputy President for this court in the Unison case as a foundation for the general constitutional principle of the rule of law, which meant that there were limits on the ability of the Lord Chancellor to impose fees for those who wished to bring employment tribunal cases. And my Lord was not deterred by the difficulty of identifying when a fee would become lawful. How much fee is appropriate did not deter your Lordship on behalf of the court from saying that the approach of the Lord Chancellor was an unlawful one because it denied in practice access to the courts and that was a breach of the rule of law read with parliamentary sovereignty. All of the cases, in my submission, all of the cases are simply illustrations of the basic principle of our constitutional law. And the basic principle is that Parliament is supreme. The executive is answerable to Parliament. And this legal concept of parliamentary sovereignty is not confined to cases where the executive ignores or frustrates an act of Parliament. It must also apply to cases, and this is a unique case to answer my Lord Carnwath, it's never before occurred. It must also apply to cases where the executive takes a decision with the purpose or effect of removing the ability of Parliament to legislate. Indeed, it's a greater breach, or could be a greater breach, of parliamentary sovereignty to prevent Parliament from legislating as it sees fit than it is for the executive to defy a particular law. The inferior body, the junior partner, the executive, cannot validly use its constitutional powers for the purpose or with the effect of preventing the superior body from performing its constitutional functions, particularly when that constitutional function is the scrutiny of the junior partner itself. That's the principle for which we contend. And there's a further analysis by Professor Paul Craig that I commend to the court. It's in the Miller Authorities, Volume 5, and it appears at tab number 79. This was published on the 31st of August by Professor Craig, tab number 79 of Volume 5. He refers in the second paragraph to the leading cases. In the fourth paragraph, he says, the salient issue in relation to prorogation is whether the Prime Minister's discretionary power should be limited pursuant to the principles underlying the case law set out above. He says the argument for an affirmative answer is compelling, and he says it's for two related reasons. First, to contend that there is some difference between the existing case law and the present situation does not withstand normative examination. The reality is to the contrary. The rationale for intervention to protect parliamentary sovereignty is even stronger than in the preceding cases. Consider the following two propositions. Parliament has enacted a statute. The executive seeks to circumvent it by recourse to the prerogative. The court intervenes to protect parliamentary sovereignty, and it does. Parliament wishes to exercise its legitimate authority through enactment of a statute or in some other way. The executive precludes this through prorogation, and the court is said to be powerless to intervene. This distinction makes no principled sense, more especially because the latter abuse of discretionary power is more far-reaching and significant than the former. The former impacts only on a particular statute. The latter constitutes a preemptive strike that takes Parliament out of the entire game for the crucial period during which it is prorogued. It affects not merely one piece of legislation, but its capacity to exercise the totality of its legislative authority, thereby severely curtailing the opportunity for parliamentary voice on an issue that, whatever one's view about Brexit, is of major importance for the UK's future. This is, moreover, the reason why judicial intervention in this instance would not signal some general judicial intrusion in this terrain. The use of prorogation in this instance is singular and warrants judicial intervention. Secondly, the case for intervention is also compelling because of the impact of the abuse of power in relation to prorogation on the sovereignty principle itself. The sovereignty of Parliament is the foundational principle underlying the unwritten UK Constitution. This sovereignty resides with Parliament, not with the executive. And he says that it represents a challenge to sovereignty since the executive in the standard case seeks to bypass an existing statute through recourse to the prerogative. It was for this very reason the House of Lords intervened to prevent this. The prorogation scenario is more far-reaching in its impact on sovereignty. The political discussion of prorogation by the present government was predicated on the assumption it could be legitimate for the Prime Minister to make use of the power intentionally, then he's turning to intention to bypass what was felt to be a recalcitrant Parliament, this is not, cannot be constitutionally correct. To subscribe to such reasoning diminishes parliamentary sovereignty as a foundational principle. It transforms the UK constitutional order such that the cards become stacked in the executive's favour. And we rely on all of that, my lords and my ladies.
Can I ask you to, if it were put to you that the government, that Parliament is indeed sovereign and the government's accountable to Parliament, when Parliament sat in early September, if it were sufficiently concerned about the prospect of prorogation, it could have held the government to account by passing a vote of no confidence in it. If Parliament has held its hand, should the courts intervene?
Well, my answer to that is that it is well established that the executive is answerable to Parliament for matters of politics. But the executive is answerable to the courts for matters of law. And I respectfully submit that this court is simply not concerned with whether or not the Prime Minister could command the confidence of the House of Commons, whether a vote of no confidence could have been brought, what the consequence of it might have been. That is, in my submission, no answer with respect to the accountability of the Prime Minister to this court for the legality of his conduct. And the authority for that is again the Fire Brigades Union case. Could I take the court back to Authorities Volume 3? It's at the Miller Authorities Volume 3. It's at tab number 42. And the relevant passage appears at 572, again in the speech, and I'm sorry, this is in the speech of Lord Lloyd of Berwick, at 572, Volume 3, Authorities, tab 42, page 572, at the bottom of the page. Lord Lloyd says this: no court would ever depreciate or call in question ministerial responsibility to Parliament. But as Professor Sir William Wade points out in Wade and Forsyth, ministerial responsibility is no substitute for judicial review. And then Lord Lloyd cites what was said by Lord Diplock in the National Federation of Self-Employed case. And Lord Diplock said this: it is not, in my view, a sufficient answer to say that judicial review of the actions of officers or departments of central government is unnecessary because they are accountable to Parliament for the way in which they carry out their functions. They are accountable to Parliament for what they do so far as regards efficiency and policy, and of that, Parliament is the only judge. They are responsible to a court of justice for the lawfulness of what they do, and of that, the court is the only judge. And we rely upon that fundamental principle. And I respectfully submit that if that argument were to be advanced against me, that Parliament could have expressed its dissatisfaction with the vote of no confidence, it is to blur the arguments of policy with the arguments of law. It is simply no answer to our submissions if they otherwise be correct. And if I'm able to show that the Prime Minister's advice to Her Majesty was unlawful, it is no answer that there could have been, in this or in any other case, a political solution. Indeed, that could always be the answer to a judicial review. It could be said in the Unison case, in the GCHQ case, in the Miller case. The Prime Minister is answerable to Parliament. But that, in my submission, legally is quite irrelevant if and to the extent, as is here the case, that the issue is a question of law.
You also seek to say that the consent of the sovereign would have been required if Parliament had limited the government's.
Your Ladyship is completely correct. That, of course, would not be an answer to the question put to me, however, by the Deputy President, because the consent of the sovereign would not have been required for a vote of no confidence. But if the argument were to be put, and it is put, I think, in the Prime Minister and the Advocate General's case, that what could have happened was a bill to remove prorogation, to alter prorogation. This is put in paragraph 9 of the written case for my friends. That would not be available because a bill which touches upon the prerogatives of Her Majesty, this is the point your Ladyship's putting to me, and I respectfully agree, a bill that touches upon the prerogatives of Her Majesty cannot be brought forward in Parliament without the consent of Her Majesty. And Her Majesty, of course, would be advised as to whether to give consent by the Prime Minister. The authority for that is Authorities Bundle, Miller Bundle, number 5, tab number 73. And it appears behind tab 73 in Bundle 5. This is from Erskine May, the latest edition of Erskine May. And the relevant paragraph of Erskine May is at paragraph 30.79. And that says, bills affecting the royal prerogative require the Queen's consent. And that's a well-established principle. I mean, what happens in practice, I can hand this in if the court is interested, when the fixed-term Parliaments Bill came before Parliament, the second reading was preceded by the then Deputy Prime Minister telling the House of Commons, I quote, "I have it in command from Her Majesty the Queen to acquaint the House that Her Majesty, having been informed of the purport of the bill, has consented to place her prerogative, so far as it is affected by the bill, at the disposal of Parliament for the purposes of the bill." That's what happens. So in practice, no bill, as my Lady Arden points out, no bill affecting the prerogative power could have been placed before Parliament without the consent of Her Majesty, and Her Majesty would have been advised by the Prime Minister. Paragraph 54 of the Divisional Court judgment refers to examples of lengthy prorogations of Parliament in the early part of the 20th century. I am, with respect, doubtful that this court is going to be assisted, much if at all, by detailed submissions on the very different circumstances in 1930, 1914, or 1901. If it matters, we respectfully submit that there is no evidence that we found that the length of the prorogation in those cases was dictated by a wish to avoid parliamentary scrutiny. And of course, those examples all occurred long before modern judicial review, in particular the GCHQ case, recognising the exercise of prerogative powers was open to legal challenge. The 1949 example that is given by my friends, where there were very short sessions of Parliament, was to ensure that the provisions of the Parliament Act 1911 could be implemented. That was not designed to prevent Parliament from acting. It was intended to allow Parliament to act to implement the Parliament Act 1949. But again,
well, intended to allow the House of Commons to act.
Well, indeed, which
not
was
Parliament,
which was permitted under the 1911 Act, as this court, I think, my lady the President was a member of the court in Jackson.
I was indeed, yes.
The court addressed that thorny constitutional issues, but that, of course, was 1949, again, long before GCHQ, and we respectfully doubt that the court is much assisted by analysis of what could have been possibly legal challenges in very different circumstances. May I then turn to justiciability? And our submission is that this case raises a legal question for resolution by the court. And the legal question is whether it is an invalid use of the power for the Prime Minister to exercise it in order to avoid parliamentary scrutiny, or with the inevitable effect of avoiding parliamentary scrutiny. Again, I rely on the academic analysis. I rely on the analysis by Professor Mark Elliott, which is in Supplemental Authorities, Volume 1, at tab number 15. And can I pick it up where I left off when I last took the court to tab 15? It's on the third page of Professor Mark Elliott's analysis. The court sees at the end, incidentally, who Professor Elliott is. He's Professor of Public Law, Deputy Chair of the Faculty of Law at the University of Cambridge, Fellow of St Catherine's College. He also served for 4 years as the legal advisor to the House of Lords Select Committee on the Constitution. And on the third page, in the final paragraph, the court sees that leads on to the question whether, notwithstanding all of the foregoing, the issues are non-justiciable. The answer to that question, an answer that largely follows from the foregoing analysis, is surely no. This is so because of what, once the issues are clearly understood, the court does not need to do in order to answer the relevant legal question. Paul Craig has correctly pointed out, that's Supplementary Authorities, tab 13, that it's misconceived to suppose that the exercise of the prorogation power necessarily involves matters of high policy. Its exercise is almost always mundane. And he says it's possible to go even further in the present context and argue the issue at stake is justiciable because it doesn't, in the first place, raise any question for judicial determination upon which an argument of non-justiciability could bite. Such questions could, at least in theory, arise if a court were asked to rule on whether 3 days or 5 days would be reasonable and so lawful duration. That would raise the sort of problem referred to by the divisional court of an insuperable difficulty where the court can't make a legal assessment of whether the duration was excessive by reference to any measure. Crucially, however, no such issue arises in Miller and Cherry. There's no need for the court to determine whether the duration was excessive. This is not, however, to deny, and this is our case, that inferences may properly be drawn from the duration of a period of prorogation when a court is determining what the true purpose, or indeed effect, was. And the government's position is the government wanted to open a new session of Parliament, hold a Queen's speech. This signally fails to explain why such an abnormally long period of prorogation has been chosen and gives rise to an inference in improper purposes at stake. Thus, far from requiring the court to determine whether the duration is excessive, the issue requires the court only to determine whether, to begin with, prorogation was undertaken for a purpose that was legally impermissible because it lies outside the range of purposes for which the power can lawfully be deployed. And that's the Padfield point, with the intention or effect of frustrating the legal principle of parliamentary sovereignty. This is a crisp question of constitutional law, says Professor Elliott, concerning the scope of the discretionary power to prorogue, as distinct from a question about whether discretion has been lawfully exercised. Such a question of law about the scope of the executive's legal powers is manifestly, says Professor Elliott, one that lies within the field of matters with which the courts can properly deal. And then I draw the court's attention to the following paragraph, which adds some further supplementary reasoning, which I won't read out. Only
it doesn't really address the authorities on the subject. Again, it's slightly frustrating to hear a very eminent academic holding forth, but without actually any reference to the authorities on the limits of review of the prerogative power.
The authorities to which I'm coming recognise in my submission that where one is dealing with a question of law, where one's dealing with the question of whether there has been a breach of the general principles of public law, the court does have jurisdiction. And I will come briefly
yes,
to the authorities.
I would have thought that was slightly more useful than with respect to Professor Elliott, because I mean, this is, to my mind, one of the really difficult issues we have to grapple with.
It is.
What are the limits of review in relation to the prerogative?
Well, I just want to show you, Lordship, because it is interesting in a field of constitutional law just what approach is taken by the leading academics in this area. Before coming to the authorities, can I also show your Lordships what is said by Lord Mance on the question of reviewability in the context of prerogative powers in giving the FA Mann lecture. That appears in the Cherry authorities, Joanna Cherry's authorities at volume 3. And it appears behind tab 67. 67, volume 3 of the Cherry authorities, tab 67. I commend all of this to the attention of the courts. Yes, MS page number 3092 is the relevant passage. It begins at 3073. And the conclusion is at page 3092. And at the top of 3092, Lord Mance, giving the FA Mann lecture on justiciability, says, drawing together the threads, my thesis is that for the most part, courts can and should adjudicate upon civil claims and public law claims without it being necessary or appropriate to resort to a doctrine of non-justiciability. There are a few ad hoc situations where an international law principle in the form of state immunity or a domestic law principle such as the Bill of Rights debars the courts from fulfilling their ordinary function. But the nature of ordinary civil claims makes non-justiciability a very rare phenomenon. Judicial review can, in contrast, range wider into areas that may potentially be thought to throw up problems of judiciability, but is subject to other controls, standing, institutional competence, discretion, which commonly make it unnecessary to grasp at so blunt a response. It continues to be the area of foreign relations in which respect for institutional or constitutional competence may most easily tip over into outright non-justiciability. There can here be no single litmus test. The political question doctrine has faded from English common law thinking. Very often it will be unnecessary and inappropriate to accept the blunt argument of a no-go area. There is a continuing shift to a more nuanced recognition that each case must be approached on its merits, weighing all relevant factors to decide whether the particular issue is really non-justiciable or whether any relief by way of judicial review should as a matter of discretion be granted. This shift would be promoted by fuller recognition that the intensity of judicial review should reflect the respective institutional competence and expertise of the original decision maker, etc., etc. And he reaches that conclusion after assessing prerogative powers. That's part of the analysis that Lord Mance adopts. And I commend all of that to the court. It's similar, not the same, it's similar to the analysis by my Lord Sales, again speaking extrajudicially. If I could take the court to that, it's Authorities Bundle 5, the Miller Authorities Bundle 5, at tab number 84, under the heading Crown Powers, the Royal Prerogative and Fundamental Rights. Again, I commend all of this to the court.
So which tab, sorry?
It's volume 5 of the Miller Authorities. It's tab number 84, my lady.
Thank you.
And at page 379, in the middle of the page, I just wanted to draw attention to this paragraph, although, as I say, all of it commands consideration. The most basic level of control of the Crown's prerogative powers is through the doctrine that the Crown only has such powers as are recognised by the courts. That is, the courts police the boundaries of prerogative power. The Crown's claims of constitutional authority are thus filtered through common law doctrine, much as the distinct claims of constitutional authority by another locus of constitutional power, namely claims of parliamentary privilege by Parliament, are scrutinised. While the common law is not exactly the source of prerogative power and parliamentary privilege, it is only to the extent that they are recognised by the common law and permitted to have operation that the authority claims which they embody are effective in law, and that involves an examination of historical claims and practices over time. And there's a reference in the footnote 88, to the proclamations case: the king hath no prerogative but that which the law of the land allows him. And we say that, with respect, is right, that the scope and extent of prerogative power is a matter for the courts to determine. The leading case...
Sorry, can I know you've got a shortage of time.
Please.
But on your present formulation, the power can not be used in order to avoid parliamentary scrutiny, or with the inevitable effect of avoiding it. Does that second half of it require a bit more sophisticated formulation? Because the Fixed Term Parliaments Act expressly allows for prorogation, and prorogation will inevitably mean no parliamentary scrutiny.
I'm not challenging the existence of a power to prorogue, and I recognise, as your ladyship puts to me, that any prorogation involves a removal for that length of time of the powers of Parliament to scrutinise. But given the junior role of the executive, our case is that it is implicit in the power to prorogue that it will not be used in such a way as to remove parliamentary scrutiny other than so far as is reasonably necessary to accomplish a legitimate objective. And here the objective that is presented is to end one session and start another with a Queen's speech. And I entirely accept that that is a decision which the Prime Minister is perfectly entitled to take. What he's not entitled to do, without a good justification, is to prorogue for a period so long that in effect, or with the purpose, it is going to frustrate, remove the ability of Parliament to scrutinise the actions of the executive. And we say, applying the Padfield principle in the context of prerogative powers, this is a decision, prorogation for 5 weeks, which either has the intention or has the self-evident effect of frustrating the constitutional principle of parliamentary sovereignty and supremacy over the executive. But I make it clear, if I haven't already done so, that of course the Prime Minister can prorogue, and of course any prorogation is going to have an adverse effect on parliamentary scrutiny. But this, we say, is a quite distinct case, given the circumstances and the length of prorogation.
Can the legitimate purposes for which the executive prorogues Parliament include the obtaining of a political advantage?
To obtain a political advantage, well, not if that political advantage is to remove the scrutiny of Parliament. No, for the reasons that I have sought to give. That, we say, is an impermissible purpose, because it is implicit in your Lordship's formulation that the executive is seeking to remove the scrutiny of Parliament. And if that is the purpose or the effect, it is not permissible. No. I mean, obviously cases are going to depend upon their facts in this context. And one needs to look very carefully at the circumstances of any particular case.
In the Cherry case, reading their written cases, it seemed to be accepted by both sides that the obtaining of a political advantage could, in certain circumstances, be a legitimate measure taken by the executive.
Well, if your Lordship's putting to me, if the Prime Minister thinks, and he does, that there are political advantages in having a prorogation because he wishes to end one session of Parliament and start another in order to have a Queen's speech that will set out his programme, his government's programme, of course, I have no quarrel with that.
I think it depends on the species of political advantage that one's speaking of.
Yes.
Your essential submission is you cannot have political advantage in the form of shutting down Parliament to avoid scrutiny.
Precisely. But I've accepted that it's perfectly legitimate for the Prime Minister to take the view, as he does, that it's time to have a Queen's speech. And in order to have a Queen's speech, you need to prorogue Parliament in order to have a new session. I have no quarrel with that. But that's a very different matter, as my Lord Kerr puts it. It's a very different matter from saying what I want to do is to have a prorogation of an exceptional length of time for the purpose or with the effect of closing down Parliament so that it cannot scrutinise the conduct of the executive. That's a very different matter. And it's a vital distinction. And I'm not asking the court to go wider than the circumstances of this unique case. The authorities, my Lord Carmouth rightly says I need to address the authorities. The leading authority is volume 4, tab 47. That's the Shergill authority, Shergill and Caira. Volume 4 of the Miller authority at tab number 47. And the relevant passage, it's in the judgment of Lord Newburgh, Lord Sumption, and my Lord Hodge, speaking for the court, tab 47, paragraph 41, which is on page 377 of the report, letter D on page 377, non-justiciability refers to a case where an issue is said to be inherently unsuitable for judicial determination by reason only of its subject matter. And the court said that such cases generally fall into one of two categories. The first comprises cases where the issue in question is beyond the constitutional competence assigned to the courts under our conception of the separation of powers. Cases in this category are rare, Rightly so, for they may result in a denial of justice. Paradigm cases are non-justiciability of certain transactions of foreign states and of proceedings in Parliament. The first is based in part on the constitutional limits of the court's competence as against that of the executive in matters directly affecting the UK's relations to foreign states, and Boots Gas is mentioned. The second is based on the constitutional limits of the court's competence as against that of Parliament. The distinctive feature of all these cases is that once the forbidden area is identified, the court may not adjudicate on the matters within it, even if it's necessary to do so in order to decide some other issue which is itself unquestionably justiciable. And that's not this case. No one suggests it's this case. The second category of non-justiciable cases is quite different. It comprises claims or defences which are based neither on private legal rights or obligations nor on reviewable matters of public law. And examples are given: domestic disputes, transactions not intended to affect legal relations, issues of international law, which engage no private right of the claimant or reviewable question of public law. Some issues might well be non-justiciable in this sense if the courts were asked to decide them in the abstract, but they must nevertheless be resolved if their resolution is necessary in order to decide some other issue which is in itself justiciable. The best known examples are in the domain of public law, and then the examples are given of some of the leading cases. And we have no quarrel, of course, with any of that. Our point is that the present case does involve a question of public law, which it is with respect for the court to determine. Is the exercise of this prerogative power in the circumstances of this case within or without the legitimate legal purposes for which that power may be exercised? And the answer is either yes or it is no. But it is an issue of law. And the rule of law, in my respectful submission, demands that the court answers it and not say it's not for us, it's to be left. It's for the discretion of the minister. The minister cannot, in my submission, have a discretion. The Prime Minister cannot have a discretion as to the breadth of the powers that he, the Prime Minister, enjoys. Many cases have been cited by the divisional court and by my friends in their written case. Can I say something about them briefly? The first is A against the Secretary of State, which is in Authorities Volume 1, tab number 5. And the court will recall that this, tab number 1, Authorities Volume 1, tab number 1, A and the Secretary of State. This was the case about the detention of foreign nationals without trial when they were suspected of involvement in terrorism after 9/11. A highly political context. Our submission being the political context in which an issue of law arises does not remove of itself the jurisdiction of the court. Miller, number 1, arose in 2016 in a highly political context, but the court nevertheless accepted that the issues were justiciable. In A...
There wasn't any dispute about it.
There wasn't. No, there wasn't. Absolutely not. In A, my friends have relied on paragraph 29 of the speech of Lord Bingham, which is at page 102. And paragraph 29 arose in the context of paragraph 16. Paragraph 16 on page 96, the heading was public emergency. And the claimants in that case were contending that detention without trial was unlawful because, contrary to Article 15 of the European Convention, there was not a public emergency threatening the life of the nation. That's the context in which Lord Bingham made the observations at paragraph 29. At letter E, Lord Bingham said, the more purely, this is page 102, the more purely political in a broad or narrow sense a question is, the more appropriate it will be for political resolution. The less likely it is to be an appropriate matter for judicial decision. The smaller, therefore, will be the potential role of the court. It's the function of political and not judicial bodies to resolve political questions. Conversely, the greater the legal content of any issue, the greater the potential role of the court, because under our constitution, and subject to the sovereign power of Parliament, it is the function of the courts to resolve legal questions. And his lordship said that the question seemed to his lordship to be very much at the political end, but nevertheless, his lordship did not rule that the issue was non-justiciable. His lordship resolved the issue in favour of the government. It's not a case about non-justiciability. It's a case about discretion and a case about margin of discretion. Indeed, to the contrary, the majority of their lordship's house, including Lord Bingham, ruled that the impugned legislation was a breach of the Human Rights Convention. Not merely was there justiciability, there was unlawful decision because a distinction was drawn between foreign nationals and citizens of this country. And at page 110, paragraph 42, at letter F to G, Lord Bingham was very critical of the submissions of the then Attorney General, who had suggested that the issues were not for judges to determine.
I suppose it's also worth bearing in mind that Lord Hoffman actually did decide.
Lord Hoffman dissented on,
yes,
on the
very point that there was
indeed he did
an emergency threatening the life of the nation. So he obviously must have considered it to be a justiciable question.
Well, I say, and I haven't got time to take the court through the judgment, all of their lordships accepted that there was justiciability, even on that highly political question of whether or not there was a threat to the life of the nation. 8 of them held that there was no breach on the merits of the provision of the European Convention, Article 15. Lord Hoffman, as my lady the President reminds me, dissented, justiciability and a breach. As to whether the distinction between foreign nationals and domestic nationals could be challenged, all of their lordships accepted and ladyships accepted justiciability. Lord Walker dissented on the merits, and 8 members of the Appellate Committee held that there was a breach of the European Convention. The case does not assist my friends. Gibson and Lord Advocate is the second case. It's volume 1 of the authorities. It's tab number 12. It's a decision of Lord Keith sitting in the Outer House in 1975. The context appears from page 139. This is volume 1 of the authorities, tab 12. At page 139, in the middle of the page, well, it's the first paragraph of Lord Keith's decision. The issue was whether the European Communities Act was contrary to Article 18 of the Act of Union 1707 and was therefore null and of no effect. That was the issue in the case, and that's because it was pointed out that Article 18 of the Act of Union talks about Scots private law and matters of evident utility. And the judgment of Lord Keith that's relied upon is at 144 in the middle of the page, in the middle of the main paragraph at page 144, Lord Keith says, "I am, however, of opinion that the question whether a particular act of the UK Parliament altering a particular aspect of Scots private law is or is not for the evident utility of subjects within Scotland is not a justiciable issue. The making of decisions upon what must essentially be a political matter is no part of the function of the court, highly undesirable it should be. The function of the court is to adjudicate upon the particular rights and obligations of individual persons in relation to other persons or to the state," etc., etc. It's unsurprising as a conclusion. I would respectfully qualify Lord Keith's analysis if it is suggested that the court's only function is to adjudicate upon the particular rights and obligations of individual persons, because judicial review has long since proceeded further than that in relation to challenges as in Miller, as in Fire Brigade Union, are to the legality of policies, decisions which have an effect on the community at large, including the individual applicant. Then there's Robinson, which is Authorities, Volume 4 of the Miller Authorities, tab 46. This was the Northern Ireland case involving the question of whether or not the First Minister and the Deputy First Minister could be appointed more than 6 weeks after the relevant date. And what is relied upon is paragraph 12 on page 398. My friends rely upon that, where Lord Bingham said matters of potentially great importance are left to the judgment of political leaders or of the Crown, where constitutional arrangements retain scope for the exercise of political judgment. They permit a flexible response. We point out that that was not a finding of non-justiciability. Far from it. See paragraph 11, where His Lordship referred to the 1998 Act and then added, but the provision should, consistently with the language used, be interpreted generously and purposively, bearing in mind the values which the constitutional provisions are intended to embody. The case of Wheeler is at volume 4, tab 48. My Lord Sales played a role here as one of the counsel for the defendants. The context, and I don't have time to go into this in detail, the context is at paragraphs 25 and 26 that Mr. Wheeler was complaining that there'd been a promise to have a referendum in relation to constitutional treaties, and he said that should apply to the Lisbon Treaty, and entirely understandably the court was unimpressed with the suggestion that it could rule that there had been a breach of a legitimate expectation in this in that context. What was legitimate? In what circumstances could the Prime Minister depart for good reason from any expectation? Standard questions in legitimate expectation law simply could not be applied in that context. Similarly, the case of Maclean, Authorities Volume 1, tab 16, a judgment of my Lord Sales. Again, can I just summarise? The claimant sought permission to bring a judicial review of the confidence and supply agreement between the Conservative Party and the Democratic Unionist Party, which the court will recall enabled the Prime Minister to form a government after the 2017 general election. And the court refused leave. My Lord refused leave for that claim to be brought. Again, we have no difficulty in accepting that the claim did not raise any tenable public law issue on which the court could adjudicate in relation to the circumstances. So we have no difficulty with any of those cases. The cases in this court include Sandiford, which is Authorities Volume 3, and to which my Lord Carnworth referred earlier, Volume 3, tab 32. This was the case, the court will recall, involving the complaint that the Secretary of State was refusing to fund legal expenses for a British national who was facing the death penalty in Indonesia. And my Lord Carnworth gave the judgment for the court. My Lord, at paragraph 50, which is on page 2712, referred to the Abbasi case, referred to the GCHQ case, and picking it up at paragraph 52, your Lordship said, for the court's role is dependent on the nature and the subject matter of the power or its exercise, particularly on whether the subject matter is justiciable. Your Lordship referred to GCHQ, referred to Bentley. Bentley, of course, was the case where there was a challenge in 1994, was it 1993, to the refusal of the Home Secretary to grant a retrospective pardon to Derek Bentley, and the Divisional Court held that that decision was unlawful. Your Lordship said in GCHQ, Lord Roskill suggested as prerogative powers which would not be justiciable, those relating to the making of treaties, defence of the realm, prerogative of mercy, grant of honours, dissolution of Parliament, appointment of ministers. Even so, it has been held that a decision to refuse to issue any pardon based on a failure to identify the possibility in law of a conditional pardon may be reviewable. It's been held that a decision to refuse to issue a passport is reviewable. In the present case, there's been no dispute the Secretary of State, in accordance with his published policies and established practice, has some responsibility for British citizens facing capital charges abroad, nor that his exercise of the responsibility is subject to review by the courts in accordance with the principles outlined in Abbasi. It's common ground. He has a wide discretion in the formulation and application of that policy. The issues turn on the restrictions on which he is entitled to place on that policy and on its application to the appellant's case. So even in that foreign policy context, there was no dispute, and the court was content to proceed on the basis that a prerogative power could be reviewable.
I mean, it was given jointly with Lord Mance, actually, for the record, but I was...
Yes, Your Lord, I apologise.
We did discuss at paragraph 60 and following the differences between review of a statutory power and a prerogative power. We certainly suggested there were different principles applying because of the lack of a text within which one was reviewed.
Absolutely, and that's why I accept it is more difficult to apply a Padfield principle in the context of a prerogative power. But the exercise I submit is a very similar exercise. It is necessary to identify, by reference to the common law constitutional principles, what are the purposes for which this power has been conferred on the Prime Minister. And in this case, the present cases, I say there is a very clear constitutional law principle which vitally informs the exercise that the court is being invited to carry out, which is to identify whether this exercise of the power frustrates the purposes for which the power has been conferred. Other cases will raise their own problems, and we're only concerned, obviously, with the circumstances of this case. But I recognise the difficulty. I say the same principles must apply. And just as Lord Reid in Padfield said he's not deterred by the absence of clear authority, I say the same applies here. I invite the court to look at principles. Two other points very, very briefly. First, I say the court is not assisted by the power of prerogative power in relation to dissolution. First, because it no longer exists, it's been repealed by Section 3 of the Fixed Term Parliaments Act, but also because it was a personal prerogative of the Crown. It was not a matter in respect of which Her Majesty was bound to follow the advice of the Prime Minister. See, and I don't take the court to it, see Authorities Volume 5, Tab 81, Houston's Essays in Constitutional Law, which some of us had not read before this case since university days, but it's at pages 79 to 80. And finally, we do submit that if my friends are correct and the court lacks, if this issue is not a justiciable issue, then my friends really do need to confront the question of what happens if another Prime Minister were to decide that he or she wishes to prorogue Parliament for 6 months or for a year. And it is no answer to that for my friends to rely on Dicey, who said that no court could assist, because Dicey, for all his wisdom, was writing long, long before the development of modern constitutional law, and Dicey himself recognises that any such conduct would be, quote, of the most unconstitutional character. In my submission, the court should arrive at a conclusion that if we are otherwise correct in our submissions, that this issue is not justiciable only if the court were to be driven to do so. It is a legal question that we are raising, and legal questions are for the courts to determine. The remedy we seek is a declaration, and we only seek a declaration that the advice to Her Majesty was unlawful because paragraph 60 of the Prime Minister's detailed grounds, Trial Bundle Volume 3, Trial Bundle Tab 3, at page 41 says, and may I quote, if which is denied the advice was unlawful, the Prime Minister will take the necessary steps to comply with the terms of any declaration made by the court. In those circumstances, it's denied there's any basis for quashing the order. Unless my friends indicate to the court that the position of the Prime Minister has changed, the court has been told that the Prime Minister will comply with any declaration, and we therefore see no reason to seek any order other than a declaration. I noticed the time. I apologise for trespassing on the lunch of your lordships and your ladyship. I'm very grateful for your patience. Those are the submissions I wish to make on behalf of Mrs. Miller, unless there are other matters the court would wish me to address.
It appears not. Thank you.
Thank you very much, my lady.
And I'm assuming, I'm afraid, that Mr. Hickman was not proposing to follow you. So your case is closed, and we will look forward to hearing from the Advocate General at 2 o'clock.
What you've done to this country.
And we were remarking about how young you look.
BBC fake news, Sky News fake news. We got a problem. We not racist! We just voted democratically! And we won!
let's start. They're recording, aren't they? Just play it out.
Coming to Nicolay. Go and see the great Nicholas Sturgeon. He doesn't accept the labor. You ain't overturning nothing. You think you are, but you ain't.
We'll leave this play out.
So after the live, I'm out of it, you know.
Stop being a rebel, mate. Turn out lovely, don't you?
See what I mean?
I don't know how you were being. You must have been like.
No, I'm all right like that. I don't mind that. Walking around doing that. I don't mind going with his kids.
Yeah, it's too okay.
It's all right standing in.
Are you here tomorrow morning? No. You can pass over there if you want. What's that? You can pass over there.
I will do.
You can't over there. You can go and sit down.
Perfect.
Shame on you, media! How you can hold your heads up! Scum! Stop listening to laugh! Deny the vote! How dare you! People smoke! Voting! How dare you!
Behave yourself.
Is
that a skinful, isn't it?
What's that?
Is that a skinful, isn't it?
Yeah. Quite a year all day. I'm doing the TikTok.
Yeah, I know, it's just like... I'm sure he's a Tottenham supporter. He's got to be, isn't it? I thought his Arsenal boys to be nice and calm and big.
I don't think so. I understand.
You've got this at my bottle of water.
Just
Thanks. I think it's supposed to be lucky, but...
I had one at about 10 o'clock. But you've had one? That's all right. You don't need one. don't want your wind, you know, only had one at 10 o'clock.
Thank you very much. See you soon. It's 3 o'clock. It's 3 o'clock, mate. Is that? The live? No, it's 3. It's half 2. I can tell.
the phone with me. If I shoved this, at least I would be able to speak to you.
I can't believe you've been so gullible today.
Don't be gullible. You were taking the bag away from me. I wasn't. I knew it was you. There wasn't anyone near me.
Any water?
Yeah.
It's rolling around. I get to it. Back.
Yeah, you can get a drink cup of it. Some of us have been here all the time. We're making gossip like you.
You've had a break at 10 o'clock. What would you want?
A break at 10 o'clock. What would you want?
I like this on break.
That's a double check with you.
It is really good. Hi, Warren.
Are you going up the phone? You burn one side.
Oh, good. You just oh, fantastic. Cheers. It's just like a way to get it out. Just a couple of bottles, yeah? 1, 2.
Yeah, I want one. So I'll give you my ball. I can back one. It's yellow.
Is that Westminster Bridge?
Oh, it's old.
Oh, yeah. Have you seen the amount of roadworks in London? It's really bad. I'm telling you, everywhere. Yeah. Andy's nice.
TBC. About that, not,
I know.
You just started me off with that. I just got rid of it. I'm not even excited.
Let's go, John. What's going to this court session closed? About 4 o'clock.
Well, I think you're doing a 6 for me, so you'll be alright.
Oh, it's past my house, mate. I won't be doing it. I'm poorly warning him.
Is it just me?
Yeah. I don't know why they should have got him down here to come about 2 o'clock. What's the point of getting him down here at 12 o'clock? They do it all the time. Because then, it's 6 o'clock, he's knackered as well.
You're always that good.
Yeah, I am.
It could be worse. I'm just going to go that way, so I'm red down both sides. Otherwise, I'll be just red down one side. You think I'm joking? I'm bloody not. I'll send you a picture tomorrow.
Have you got no sunscreen?
Hey, I have, yeah. I've got to put my bum. Didn't get me bum ball. Oh, that was close. What was that?
It's all that stuff.
Oh, I thought it was bird foot. If we're going slowly but surely, well, that's what we cruise.
No, I think there's gaps opening up here now, isn't it? Yeah. It's too much to move, isn't it?
All of that, yes. And it's too close to them.
so I'm so happy about getting the other side done. Sorry? No, he's not even in the country, no. No chances, not yet. Just don't trust me behind me. I don't mean in that way, I mean you saved your life. That's what I mean.
This must be like a design along the courts. It's a high courts like this, isn't it?
Now they've got it, yeah. But not as close as this. This is quite handy, isn't it? Yeah. In fact, if you like, so they just need a lift, then you can have a little pool. You can have a really good
My ladies, my lords, in respect of the appeal from the inner house of the Court of Session, I would invite the court to recall the interlocutor of the inner house and to dismiss the petition. In addressing the court, I'm conscious that there are issues both of fact and law that require to be touched upon. And as my learned friend, Lord Panic observed in his opening, it is intended that to a substantial extent, my learned friend, Sir James Eadie, will address the detailed aspects of the authorities and law applying in respect of justiciability. Nevertheless, it's a topic upon which I will have to encroach to some extent in order to complete my submissions. I also have to anticipate the case to be made in this appeal by my learned friend, Mr. O'Neill, and your lordships will have had the opportunity to see his written case that perhaps goes beyond, in some contexts, the decision of the inner house itself. So what I would like to do at the outset is to identify those areas, 3 areas, where we are in agreement with the decision of the inner house, or at least the majority opinion in the inner house. And the first matter that I would seek to address is this. The inner house accepted that the determination of this case does not depend upon the particular terms of the claim of right or any speciality of Scots constitutional law. That was the opinion of the Lord President, to be found at paragraph 51 of his opinion, which is at MS 1209. And perhaps I could simply ask the court to note his observation that, albeit that there could be an issue as to whether or not an act was lawful or unlawful, this is not because of the terms of the Claim of Right 1689 or of any speciality of Scots constitutional law. It follows from the application of the common law informed by applying the principles of democracy and the rule of law. And he refers there to the Lord Hodge in the case of Mearn. To the same effect is Lord Brodie at paragraph 81 of the inner house judgment, which is at MS 1226. And there he observed that there had been no contravention of the claim of right, which was part of the case which had been advanced on behalf of the petitioners. And indeed he observed about halfway down that paragraph that while we heard much from Mr. O'Neill on behalf of the petitioners, which was both interesting and stirring about a particularly Scottish tradition of holding the Crown in its various manifestations to account for present purposes and not having actually identified any material differences between the applicable Scots law and the corresponding English law, Mr. O'Neill was to an extent pushing at an open door, however only to an extent. Lord Drummond-Young didn't address the matter directly in the same way as the Lord President and Lord Brodie, but your lordships may note that in his opinion at paragraphs 97 and 98, which can be found at MS 1237, he refers to the constitutional system of the United Kingdom. Now that is hardly surprising, I venture, when we're dealing with the prerogative powers which may be exercised with respect to the Parliament of the United Kingdom, and indeed also when we come on to consider the privileges of that United Kingdom Parliament. And I note, and your Lordships may have seen this already, that this is also consistent with the written case submitted for the Lord Advocate in footnote 6 of that case. I'm afraid there are no MS references that I'm aware of. He notes, however, the prerogative at issue here is the power of the Crown in right of the United Kingdom to prorogue the United Kingdom Parliament. The legal content and effects of that prerogative cannot sensibly differ as between the different jurisdictions of the United Kingdom, nor at the level of constitutional principle, should there be any difference of approach between the different jurisdictions of the United Kingdom as regards the proper role of the court in reviewing the exercise of that prerogative. The important thing is that the correct approach should be taken in that regard in both jurisdictions. Now, for reasons which I'll come on to elaborate, I would simply wish to refer the court to some authority that underpins the proposition that in addressing the prerogative as it applies to the United Kingdom Parliament and considering the privileges of that Parliament, one has regard to common principles of public law throughout the United Kingdom. I just note in passing that the matter was addressed in the case of Burma Oil against the Lord Advocate as long ago as 1965, when the court observed that it would be highly unusual, if not surprising, if the application of these matters differed as between the north and the south bank of the Tweed. I would also refer to the case of Adams against Guardian newspapers, which was an outer house case in which the judgment was given by Lord Reed. That can be found at MS 1325. And there, at paragraph 13 of that judgment, Lord Reed observed as follows: there is little modern authority in Scotland on the issue of parliamentary privilege, but it was common ground before me, and it appears to me to be clear that the law on this matter is in general at least, and subject to any divergence arising in consequence of other differences between Scots and English law, e.g. as to procedure, the same in Scotland as elsewhere in the United Kingdom. No difficulty arises in particular from the fact that the Bill of Rights was passed by the Convention Parliament in England and had its Scottish equivalent in the claim of right, the latter being less specific on the issue of freedom of speech. As Mitchell, in his work on constitutional law, explains, doctrines of parliamentary privilege were more fully developed in 1707 in England than in Scotland, and it was therefore natural that the greater should be accepted as the basis of the privileges of the Union Parliament, quite apart from the natural tendency of that Parliament to refer to precedents which were familiar to the majority of its members. And that judgment was in turn approved in the case of Coulson against Her Majesty's Advocate, a decision of the High Court of Justice, essentially the equivalent of the Criminal Court of Appeal, in 2015. I should say that there are also echoes in my Lord Reed's observations of the evidence which the late Lord Roger, in his capacity as Lord President of the Court of Session, and Sir Robert Carswell, in his then capacity as Chief Justice of Northern Ireland, gave to the Joint Committee on Parliamentary Privileges, where they made clear that they were convinced that the law would be interpreted in Scotland and Northern Ireland to reflect closely the interpretations placed upon parliamentary privilege by the English courts. So it is quite clear that the decision in the Inner House and the divisional court decision in Miller did not result from any substantive difference between English law and Scots law, because as the Inner House held, in this context, there simply wasn't any such difference to be relied upon. My lady, my lords, the second matter of agreement with the Inner House is that the prorogation of Parliament does not have a direct consequence on individual rights. And the Inner House rejected the petitioner's argument that the issue was rendered justiciable on that basis. The Lord President addressed the matter at paragraph 59 of his judgment, which can be found at MS 1212. And really very briefly said, however, the proroguing of Parliament does not have a direct consequence on individual legal rights. The issue is not justiciable on that basis, and the petitioner's argument to the opposite effect on this point is rejected. And again, Lord Drummond-Young, at paragraph 125, which is at MS 1253, simply observed, finally, I should express concurrence with the views of your lordship and the chair on the question of redaction of documents supplied and the proposition that proroguing Parliament does not have a direct effect on individual legal rights. So again, I seek to put that issue to one side, albeit it may re-emerge as my learned friend Mr. O'Neill presents his submissions to the court in light of his written case. The third matter of agreement with respect to the Inner House is the acceptance by a majority of their lordships that a principle of non-justiciability exists in public law and that whether an issue is ultimately justiciable will depend upon the subject matter. And that can be found, first of all, in the opinion of the Lord President at paragraph 50, which is at MS 1208. Where he observed the decision under review, which seems to be made by the Prime Minister alone, is that to request Her Majesty the Queen to exercise her prerogative to prorogue Parliament. A prerogative decision may be the subject of a judicial review, reference to Bancroft. Whether the issue is ultimately justiciable will depend upon the subject matter, and a reference there to Lord Scarman and Lord Roskell in the GCHQ case. To similar effect, we find Lord Brodie at paragraphs 83 to 85 of his opinion, that's at MS 1226. And I won't seek to take your lordships through the entirety of that passage, but again, he appears to approach the matter on the basis that there may be an issue of non-justiciability and that it will be determined by reference to the subject matter of the case. In particular, at paragraph 84, he also made reference to the Sandiford decision that was mentioned by my learned friend, Lord Pannick. I should add, however, that Lord Drummond-Young dissented on this point, and I simply ask your lordships to note that that can be found at paragraphs 102 to 103 of his opinion, which is at MS 1240. But looking to the majority decision in the Inner House, again, on this third point, it is clear that the Inner House accepted the principle of non-justiciability in public law, and that ultimately justiciability would depend upon the subject matter before the court. And that, I would venture, is clearly consistent with extensive authority, which is set out in our written case, essentially from paragraph 55 onwards, and which my learned friend, Sir James Eadie, will address in due course and in more detail. So again, I put those three issues to one side at this stage. The next point that I would seek to address with the court concerns the interlocutor pronounced by the Inner House on the 11th of September this year. And that can be found at MS 505. And if I might refer the court in particular to part 4 of the interlocutor, which was pronounced after they had reversed the decision of the Lord Ordinary and allowed the reclaiming motion. And it is in these terms: find and declare that the advice to prorogue Parliament on a day between 9th and 12th September until 14th October 2019, and hence any prorogation which followed thereon, is unlawful and thus null and of no effect, and discern. Now, insofar as the Inner House seek to declare the prorogation unlawful, I will take no issue with their order. But insofar as they purport to declare that prorogation is null and of no effect, I submit that they have simply gone where the court could not go. As your lordships will be aware, prorogation may be by the sovereign in person. That has not happened in recent years. I believe the last sovereign to prorogue Parliament in person was William IV. But alternatively, it may take place by Lords Commissioners acting on a commission from the sovereign. Those Lords Commissioners summon the House of Commons and the Speaker of the House of Commons to the upper chamber and declare under the authority of the Great Seal that Parliament is prorogued. These are proceedings in Parliament, and consistently with the law of parliamentary privilege, which is common to both England and Scotland, such proceedings should not be impeached in any court. And in that context, of course, I would make reference to Article 9 of the Bill of Rights, which for reference can be found at Authority 43, MS 2893. And I would also refer to the claim of right, albeit its wording is rather different and less direct, which is in the Authorities Bundle at 44, MS 2902. So my submission at this stage is that on any view, Part 4 of the Inner House interlocutor must be recalled. And I understand...
It's quite a difficult concept, isn't it, Lord Keane? This is unlawful, but it's valid.
It is because the courts are not to cross the boundaries and intrude upon the proceedings in Parliament. They may make the appropriate declarator, and I would take up a point mentioned towards the end of his submission by my learned friend, Lord Pannick. If this court finds that the advice of the Prime Minister was unlawful, the Prime Minister will take all necessary steps to comply with any declaration made by the court. And that is the appropriate way in which this matter should be addressed.
Well, that dispenses with the problem, you might say.
Well, indeed. And I understand that, in fact, the Speaker's Council have advised that as far as they're concerned, Parliament is prorogued at the present time, and it is to dispense with any debate over that issue that I draw particular attention to Part 4 of the Inner House Interlocutor, because it did actually generate debate as to whether or not Parliament should or should not be sitting at the present time.
We have got an awful lot to think about in this case, have we not, Lord Keane?
Indeed.
And whether this is or is not a proceeding in Parliament seems to me to be an extremely difficult question.
But it is, if I might venture, my lady, perhaps one that we can essentially put aside if the court is willing to accept the undertaking
that we do.
That I have given on behalf of the Prime Minister.
It may be necessary just to hear the refutation of your point before we decide to put it to one side. We'll wait and see.
Very well.
Yep.
I
appreciate that the activity takes place in the Houses of Parliament, but that in itself is not enough to turn it into a proceeding in Parliament.
So I indicated, my lady, I would submit that the conduct, whether it be of the Sovereign, of the Lords Commissioners, are proceedings in Parliament and should not be questioned by the court. But it may be that we can allow further debate on that issue in light of the undertaking which I am prepared to repeat on behalf of the Prime Minister and indeed the Executive.
What's the effect of the undertaking? What happens if this court does declare the prorogation unlawful? Does Parliament then reconvene?
It will be then for the Prime Minister to address the consequence of that declaration and to consider...
What other consequence could there be?
Well, the consequence could be that he goes to the Queen and seeks the recall of Parliament.
He has other alternatives, you say, does he?
Well, as I say, I have given a clear undertaking that the Prime Minister will respond by all necessary means to any declaration that the original prorogation was affected by any unlawful advice that he might have given for the purposes of the original prorogation.
Can we take it then he wouldn't apply to have Parliament prorogued again?
I'm not in a position to comment on that proposition at all, my Lord.
That's why I'm personally very interested in what you say the effect is, because abiding by a declaration conjures up a number of possibilities.
That will have to be addressed by the decision maker, my Lord.
It would be helpful to have the undertaking all given in writing, so we're absolutely clear what you're...
Well, I'm content for that to be done, my Lord. As I say, the terms of the undertaking I give is that if the court finds that the advice of the Prime Minister was unlawful, the Prime Minister will take the necessary steps to comply with any declaration made by the court.
That's slightly different from the order of the Scottish Court, which was not that the advice was unlawful, but that the prorogation was unlawful. I mean, are you accepting that if the advice was unlawful, then the prorogation is unlawful?
The position, as I understand it, is that the complaint from the petitioners is that the advice given to Her Majesty was unlawful, because the decision...
Yes, I understand that.
Because the decision of Her Majesty to prorogue cannot be impugned.
Well, for my part, it would be helpful if between you and Lord Panic you can work out and give us a clear formulation of what you say you're prepared to undertake.
Well, I'm content to speak to my learned friend Lord Panic to see if we can agree a formal draft in that context.
Without that, we would have to rule on your Bill of Rights point.
Indeed so.
If you're not prepared to respond to Lord Kerr's question, that there's no undertaking not to prorogue again, will the undertaking give Parliament an opportunity to decide whether it wishes to pass any legislation before that happens?
Well, my lady, it must be for the decision maker to consider the declaration made by the court and to ensure that he proceeds lawfully thereafter.
Can I ask Lord Keane what the status is to be of the order in council granting prorogation?
Well,
or ordering prorogation.
The order in council is the instrument by which the Lords Commissioners are engaged to prorogue Parliament, but it is merely an instrument for that purpose. It is possible for an order in council to be impugned. I quite accept that, and there is authority for that proposition. Doesn't follow that all orders in council it can be impugned.
Now, are you saying that its effect is spent?
It would be spent in those circumstances, my lord, yes, because the order in council directs the prorogation from a particular date to another particular date. Sometime between the 4th and 9th of September and the 14th of October of this year. Lords, the focus of the submissions that I now make will be on the detailed reasoning of the Inner House at the Quarter Session, in the context of the Inner House having agreed with the principle of non-justiciability in public law. What the Inner House then sought to do was to apply an exception to that principle. And I will submit that they then erred in the inferences which they drew from the circumstances of the case before them. And I would observe that these are inferences that the Lord Ordinary, who heard this case at first instance, was not prepared to draw. Furthermore, I venture that an examination of the inconsistent reasoning in the three Inner House opinions tends to reveal the very absence of manageable judicial standards for the exercise that the Inner House purported to carry out. The Inner House sought to apply what they regarded as a proper purpose or improper purpose to the exercise of the prerogative of prorogation. Various terms were used in the opinions of the Inner House: formal purposes, standard use, proper purpose, intended scope. But as we seek to set out in some detail in the written case at paragraph 87 through to 90, the prerogative of prorogation is not exercised for one or more limited purposes. And I would submit, for the reasons explained in the case at paragraphs 88 to 90, that an improper purpose doctrine or test has no sensible application to the exercise of the prerogative power of prorogation. The determination of what are proper and improper purposes, for which, for example, statutory powers can be used, depends clearly on identifying the policy and objects of the relevant statute. And my learned friend, Lord Panic, made reference to the case of Padfield. That, as Padfield makes clear, is a question of statutory construction, and I would submit that no similar exercise can be conducted in respect of the prerogative power prorogation as opposed to, for example, a power exercisable under a prerogative instrument. And we know that Parliament may be prorogued for a variety of reasons, political as much as formal. And certainly, the power to prorogue Parliament is not in any sense limited to the preparation of a new Queen's speech. That was a point which the Divisional Court made very clear in its own judgment, and I refer there in particular to its judgment at paragraph 55. Indeed, the Divisional Court went on to observe that even if one was looking only at the matter of the provision of a new Queen's speech, it was not for the court to determine how much time might be contemplated as necessary or required, even for that purpose alone. In the course of his submissions, my learned friend Lord Pannick did not make reference, as I recollect, to the Prorogation Act of 1867. And I wonder if I could just draw that to the court's attention. It's in the Petition Authorities bundle at tab 48 and can be found at MS 2922. Just looking very briefly at the provision of section 1, whenever Her Majesty shall be pleased by and with the advice of the Privy Council of Her Majesty, in this context, of course, the Prime Minister or the Executive, to issue her royal proclamation to prorogue Parliament from the day to which it shall then stand summoned or prorogued to any further day, being not less than 14 days from the date thereof, such proclamation shall, without any subsequent issue of a writ or writ's patent or commission under the Great Seal of the United Kingdom, be a full and sufficient notice to all persons whatever of such royal intention of Her Majesty. And the Parliament shall thereby stand prorogued to the day and place in such proclamation appointed, notwithstanding any formal law, usage, or practice to the contrary.
But that isn't what happened in this case.
That is not what happened in this case, but the point, milady, is simply this, that Parliament has made express provision that where Parliament stands prorogued, it may be prorogued for a further period of at least 14 days, by exercise of the prerogative. And that is not, on the face of it, related to a Queen's speech. And indeed, if you go on to section 2 of the Act, it provides this Act shall not apply to the case of the prorogation of Parliament at the close of a session.
What was the purpose for the prorogation in this case?
I'm going to come on to address that in some detail, my Lord, because various assertions have been made touching upon the proposition of improper purpose, and various inferences have sought to be drawn which are adverse to the purpose which was put before the court. And therefore, as I say, I will come on to address that in some little detail. But before I go there, can I just take this a stage further? Because there are clear examples of where the prerogative has been exercised for political reasons, rather for formal reasons, and indeed for extensive periods of time. And my learned friend, Lord Pannick, said, yes, but these were of some vintage, as it were. given that he's seeking to found upon principles of constitutional law that have developed presumably over the last 300 years or so since the Bill of Rights, it doesn't seem to me inappropriate to look at how the matter has been addressed in the interim. And if, perhaps most conveniently, your lordships can refer to our written case at paragraph 71. And I regret there seems to be no electronic numbering for the case. And just put in context, at the beginning of paragraph 70, it's observed, in giving advice on prorogation, the Prime Minister will necessarily take into account matters that are political. And it goes on, the history of the power to prorogue Parliament supports the fact that it has been used for political purposes, including for the purpose of restricting the time otherwise available to debate legislation and for prolonged periods, including at moments of political importance and when the government of the day lacked a majority in the House of Commons. And the first example is given in respect of September 1914, shortly after the outbreak of the First World War, where Parliament was initially prorogued until 27th October, with the King's speech on prorogation noting that the circumstances, and I quote, call for action, not speech. And on 16th October 1914, Parliament was further prorogued by proclamation until 11th November 1914. And that clearly was not for the purpose of a King's speech. And then the second example, on 1st August 1930, Parliament was prorogued until 28th October, a period of 87 days. And this was during the onset of the Great Depression, following the 1929 Wall Street crash, when the new government of James Ramsay MacDonald did not command a majority in the House of Commons. And again, that was clearly not for the purpose of delivering a King's speech. One might observe, rather, that it was clearly so that the executive could avoid unnecessary scrutiny in circumstances where they did not, on the face of it, command the confidence of the House. And then the third example, which was touched upon by my learned friend, was the case in 1948, where under Section 2 of the 1911 Act, a non-money bill could only be enacted without the consent of the Lords if it was passed in 3 successive sessions by the Commons. As noted below, each session of Parliament conventionally lasts for approximately a year. To facilitate the speedy passage of the Parliament Act 1949, the government arranged for a session of minimal length in 1948. Parliament was prorogued on 13th September 1948 to the following day. Following the passage of the Parliament Bill by the Commons, it was then prorogued again on 25th October 1948. The King's speech, which closed the session, expressly noted that the two houses have again failed to agree on the bill to amend the Parliament Act 1911. Now, this last example was clearly for a party political purpose. It was carried out in order that the then executive could avoid scrutiny of its legislation in the House of Lords, potential defeat in the House of Lords, and ultimately in order that it could overcome the opposition of a majority in the House of Lords for the passage of its intended legislation. And to describe that as somehow some formal use of prorogation is very far from the truth. It was clearly a naked political use of prorogation by the executive to essentially force through Parliament its intended legislation, notwithstanding the knowledge that it had no consent of a majority in the House of Lords in order to achieve that political objectives.
But of course it could be said, could it not, and Lord Keane, that it was in order to enforce the will of the House of Commons, that is the democratically elected will of the House of Commons, and thus in pursuit of democracy rather than against it. It could be said.
Well, I would take issue with that, my lady, particularly if one examines the circumstances which pertained in Parliament in 1948. The 1911 Act was passed in its form for a reason, and that was to allow the House of Lords the opportunity to also take part in the passage or otherwise of
I'm aware of that,
affirmative legislation, clearly.
It could be said that this was the House of Commons asserting itself against the House of Lords. That is the democratically elected House of Parliament against the then, at that stage, wholly hereditary House of Lords, apart from the Law Lords.
Indeed so, my lady. Well, in fact, at that time, the Law Lords would have been hereditary as well, would they?
No,
unless they were appointed under the 18...
They were the first. They were the first life peers.
They were the first life peers. Yes. My lady's quite right. But with regard to this matter, it's quite clear that even if one attempts to drill down into what happened in 1948 or 1930 or 1914, prorogation is not being employed here for formal purposes, for standard purposes, or for non-political purposes. It is clearly being employed in circumstances where the executive wished to pursue a particular political objective, and they are entitled to do so. Now, the Inner House does very little to expressly address this issue, but it is clear that in taking its own approach to the exercise of the prerogative of prorogation, I apologize, that it is seeking to apply what might be regarded as an improper purpose test. And one sees that in the opinion of Lord Drummond-Young at paragraph 104. I won't necessarily take your lordships to all of these references, but if you note them, it's at MS 1242, where he talks about the exercise of the prerogative in this case as being out with its intended scope, without actually defining its intended scope. And again, at paragraph 106, which is at MS 1243, he refers to proper purposes. At paragraph 108, he refers to its standard use. That's at MS 1243. And then goes on to refer to its formal purposes at MS 1244. He does refer to the circumstances of the Parliament Act 1949, but observes simply that this cannot serve as a precedent. Well, with respect, it is a clear example of the prerogative being exercised with a clear political aim. And what one can take from these examples is that the exercise of the prerogative is clearly not limited to some formal or standard purpose, with the result that where it is employed elsewhere, one can infer some improper purpose. Despite that, Lord Drummond-Young at 116, which is at MS 1248, goes on to require what he refers to as a valid reason. Now, if the court requires a valid reason, then it would surely require to identify an invalid reason, and in particular, an invalid political reason, because it's quite clear that the reasons for seeking to exercise the prerogative of prorogation may be political rather than formal. And in the same vein, the Lord President at paragraph 50 of his judgment uses the language of, and I quote, legitimate political considerations. And again, if we go down that road, it will require the court to identify what is an illegitimate political consideration. So the effect of the Lord President's language is to apply a political purpose test. of some kind. And then Lord Brodie, at paragraph 91 of his opinion, refers to what he termed egregious illegality as an improper purpose case. So again, we have reference to purpose, political purpose, legitimate or illegitimate, as being the touchstone, apparently, for the courts to address this matter. But as was noted by the court in Padfield, one cannot test propriety of a purpose which has not been conferred by a particular statutory scheme. Because without a statutory scheme, you have no yardstick against which to measure whether the exercise is proper or improper.
Well, say for example, honours were being granted on the basis of bribery and corruption. I don't imagine there's any statute that governs the award of honours. Would that not be, on any view, improper?
It might be improper, but the remedy would lie in the political field, and the other legal requirements with regard to bribery and corruption.
But could it not be declared unlawful? Take my Lord's example.
It appears to me that to do that, the courts would have to impinge upon the exercise of the prerogative in an area which is not justiciable, and therefore, no, it could not be declared unlawful by the courts.
Unless it was a breach of the criminal law.
Well, that's a different matter. If the matter was brought on the basis that there was to be a prosecution, then clearly the courts engage in that. If the matter was to be brought on the basis of a civil claim arising out of that. But in the context of the actual exercise of the prerogative, that could not be impugned. And indeed, it raises a point that was touched upon in the Inner House, because the court raised the question of what would happen if it appeared that the advice to prorogue Parliament had been secured by bribery. About the most extreme example that could be thought of. And in my respectful submission, the remedy for that would lie in regard to the penalties for bribery and corruption, and would lie in the political field in respect of those who'd engaged in it. But it would not render the exercise of the prerogative amenable to justiciability before this court. That would be to ignore the boundaries set out with respect to the separation of powers. Where Parliament wishes to determine when it does not wish to be prorogued, then Parliament, can and indeed does address this by primary legislation. The legal limits on the power of the executive are, in other words, set by Parliament and not by the courts, insofar as it concerns the exercise of the prerogative to prorogue. And there are, of course, a number of examples of where Parliament has exercised that right of control by the use of primary legislation. And examples are given in the written case at paragraph 28, but shortly put. They include section 5 of the Succession to the Crown Act, 1707, which can be found at MS 2917. Section 52 of the Reserve Forces Act 1996, which can be found at MS 2925, and Section 28 of the Civil Contingencies Act 2004, which can be found at MS 2927. In each case, Parliament has applied controls upon the executive with regard to the circumstances in which it may or may not be prorogued according to particular circumstances. But of course, the most recent example of this can be found in Section 3 of the Northern Ireland Executive Formation Act 2019, and in particular Section 3 of that Act, which emerged as a result of the amendment in the House of Lords by David Anderson QC, Lord Anderson of Ipswich, to introduce a mechanism whereby Parliament could require to be recalled for certain periods and at certain intervals between September 2019 and 31st October 2019, indeed going on to December 2019, in circumstances where it was either prorogued or adjourned by reference to recess being what appears to have been contemplated.
Where do we find Section 3?
MS 2951, my lady.
Thank you.
And there's a detailed analysis of its terms set out in the written case as well. And I'll come on to it in a little more detail, if I may, in a moment. But when the Inner House came to address the provisions of that Act, it appears, in my respectful submission, that the majority fell into error with respect to the provisions of Section 3. Lord Brodie, however, and this was at paragraph 72 of his judgment, which is at MS 1220, correctly held that the business which Parliament addressed when sitting pursuant to Section 3 would be for Parliament to determine, because it was going to sit for a period of 5 sitting days at certain intervals as a consequence of a report being required to be made to Parliament concerning the formation or otherwise of a Northern Ireland executive at Stormont. Lord Drummond-Young, by contrast, and this was at paragraph 114 of his judgment, MS 1247, suggested that the sittings of Parliament pursuant to Section 3 of that Act would be limited and related to the formation of an executive in Northern Ireland. There is, with respect, no such limitation in the Act, and indeed it might be difficult to conceive of circumstances in which Parliament would have to debate the non-formation of a Northern Ireland executive for 5 days. The Lord President took a similar view to that of Lord Drummond-Young, and at paragraph 56 of his opinion, at MS 1212, suggested that the Act was designed primarily to relate to the formation of a Northern Ireland executive. Now, I venture that Lord Brodie was clearly correct in this context. When Parliament was legislating for a period encompassing the exit date, with 5 days of debate for each of those occasions, it clearly, I suggest, had in mind the exit date itself of 31st October 2019. But perhaps the most notable aspect of Section 3 of the Northern Ireland Executive Formation Act is that from its terms we can clearly discern that Parliament anticipated that it might be prorogued or adjourned in the period between September and 31st October 2019 and legislated accordingly. If Parliament had not intended or wished to be prorogued or adjourned for longer than the period specified in Section 3, then it could and presumably would have said so. But I venture that it is not for the inner house of the Court of Session to say to Parliament that over and above what Parliament has determined by primary legislation as to its sittings in that period, the Court considers that they should be sitting for longer.
Whilst we've got section 3 out, once the first report's been laid, there's an obligation to lay a subsequent one. And in that circumstance, it has to be laid before each House of Parliament by the end of the day on which it's published. So there has to be by the 9th of October. Is there going to be another sitting for that to happen?
I understand that the next sitting would be on or after 14th October. Because as I understand it, under parliamentary procedure, the report is deemed to be laid when Parliament returns.
That wouldn't be within the period, would it?
Well, that is the view, certainly, that has been expressed. There may be an alternative view, but that certainly is the view that has been expressed, that under parliamentary procedure, the report made would be deemed to be laid on the day Parliament returns.
Thank you.
But I'll take steps to check that.
That would be helpful. Thanks.
Well, it would have to be deemed to be laid on or before the 9th of October to comply with section 3, subsection 5.
Wouldn't be regarded as laid during recess.
No, it wouldn't. So what you're saying is that somebody has said to you that once Parliament returns on the 14th and it's then laid, this is deemed to have been laid on the 9th. That's what you're telling us.
No, I don't believe I am. I'm saying that where the statutory provision provides for the laying of the report, it may be produced on the 9th, but under parliamentary procedure, it will be regarded as having been laid on the 14th in order that the relevant...
But the problem is that that doesn't comply with the timetable in the statute, because it has to be a report on or before the 9th of October, and then it has to be laid by the end of the day on which it's published.
But it's the latter point, by the end of the day, as I understand it, and I will take steps to check this, but the report would be made on the 9th of October, but it would actually be regarded as laid when Parliament returned from recess.
Okay.
And that would be regarded
I'll leave it
in that context as the end of the day, but I will take steps to confirm that.
So is the report published on your understanding on the 9th, but treated as laid on the 14th?
That is my understanding, my Lord.
Notwithstanding that the initial report quite clearly must be laid before Parliament on the end of the day on which it's published.
Indeed so. And it's the use of the term the end of the day in the context of Parliament potentially being in recess, for example.
No, on the end of the day on which it is published.
I quite understand the difficulty, my Lord, and the provision has been looked at.
Well, I'd welcome. I know your time limits. Your time is limited, but I'd welcome some clarity on this, perhaps later on.
Can I indicate to the court that I will return to that in my reply once I've clarified what the position is understood
Thank you.
to be? But that is my understanding of the position at the present time. The point that I seek to make in the context of Parliament having passed Section 3 of the 2019 Act is this. Parliament had the opportunity and the means to determine where and when it would and would not be prorogued or adjourned in the period from September up to, indeed, December of 2019. If Parliament had wished not to be prorogued or adjourned for any longer period in that period or in that time, it would have been able to address that matter itself by way of primary legislation. It did not do so.
Subject to
this
consent
Act
of the sovereign.
came into force on the 24th of July. Was there any suggestion from any official source on the 24th of July of any intention to prorogue Parliament over a period which included the 9th of September?
Milady...
No, sorry, 9th of October?
Milady, that must have been anticipated because that explains the wording that was employed in Section 3 of the Act.
But
Parliament clearly anticipated that it might be prorogued or adjourned over that period. That is the whole purpose of Section 3. If we are prorogued or if we are adjourned, then we demand to be recalled. And that is the mechanism that Parliament determined should apply. If there had been no contemplation in anyone's mind of Parliament being prorogued or adjourned, it is difficult to conceive of how Section 3 would have emerged into the Northern Ireland Executive Formation Act. The latter being what might be termed a convenient vehicle for the amendment that was introduced in the House of Lords in order to introduce what is now Section 3 of the Act. But what I say is it is quite clear from the terms of Section 3 that Parliament did contemplate that it might be prorogued or adjourned during the relevant period. That must be the case.
If one proceeds on the premise that there was inaction by Parliament when action could have been taken, what is the significance of that?
Well, the significance is this, that if and when Parliament does not wish to be prorogued by exercise of the royal prerogative, Parliament controls that process by means of primary legislation. The issue is determined by Parliament. It is not determined by the courts. Parliament having determined the issue by using primary legislation, we now have the court coming forward and saying, notwithstanding this, we in turn wish to overlay your primary legislation with a requirement that Parliament should sit for longer. And I say that's a simple intrusion into the position of Parliament, and it's a decision that does not respect the separation of powers.
Is it not possible that Parliament did not anticipate in July that there would be a prorogation of 5 weeks?
Well, I'll come on to the period of the prorogation in a moment, if I may, my lady, but assuming that was the case, when Parliament was sitting at the beginning of September, it then proceeded to pass the European Withdrawal No. 2 Act, which determined that essentially the executive should not proceed to exit the European Union without a deal and should instead secure an extension. And if at that stage Parliament considered that it needed to ensure that it would not be prorogued or adjourned for a longer period, it had the means to do so. That bill passed Parliament in 2 days. So whether it be the Northern Ireland Executive Formation Act in July or later, the legislation that formed the European Union Withdrawal Act No. 2, the fact is that Parliament had the means to secure whether it would or would not be prorogued or adjourned during a period up to and including 31st October. Parliament exercised its ability to set the limits on the power of the executive to use the prerogative to prorogue Parliament. And having set those limits, it is not in my submission for the courts to overlay that primary legislation with their own views to when Parliament might or might not sit. That is to intrude over the boundaries of the separation of powers. There are more than adequate mechanisms to determine limits upon the exercise of the prerogative prorogation, but they are exercised by Parliament using primary legislation. So that being the position, if I can move on slightly, I pose this question. How then did the Inner House come to hold that the exercise of the prerogative to prorogue Parliament could be challenged? As I noted earlier, the majority, namely the Lord President, get me some water, and Lord Brodie, recognised the principle of non-justiciability founded upon the subject matter test. And as I also noted, the Lord President held that decisions that are made on the basis of legitimate political considerations are not justiciable. Lord Brodie suggested that justiciability could depend upon the particular circumstances of an individual case. That was his opinion at paragraph 84, and particularly where the case was, as he described it, extreme or egregious. But that, of course, is not the subject matter test, which he's previously acknowledged is the relevant test to apply in the context of justiciability. The subject matter test is applied by reference to the nature of the power, not the facts of the individual case. That, I submit, is clear from the authorities that my learned friend Sir James Eadie is going to come on to address. And I hesitate before, as it were, trampling on that ground, as it were. Now, clearly, the exercise of the prerogative in respect of prorogation, or indeed dissolution prior to the Fixed Term Parliament Act, is a matter of political judgment. And one cannot dismiss the position with regard to dissolution simply because of the emergence of the Fixed Term Parliament Act. Again, if my learned friend Lord Pannick is praying in aid a constitutional tradition that embraces principles that have essentially emerged over 300 years, then I believe we're entitled to look at what has happened during that period. And one thing that has clearly emerged is the belief by the courts that the matter of dissolution of Parliament is preeminently not justiciable. Of course, I accept matters have moved on since Lord Roscoe spoke in GCHQ, but that remains a constant theme. It has always been identified as one of the paradigm examples of non-justiciability. And one cannot dismiss that simply because of the Fixed Term Parliament Act. And the Fixed Term Parliament Act, of course, in turn, at Section 6, expressly preserved the prerogative of prorogation. Now, if, as the Lord President suggests in his opinion at paragraph 50, such a power is only non-justiciable when based on legitimate political considerations. Legitimate political considerations. How is the court going to be equipped to decide what these are, or indeed what they might even be? In my respectful submission, the Lord President has nakedly entered the political arena by going down this particular road.
Isn't he saying there are political considerations which offend the law, rather than some political considerations are legitimate and some aren't?
In my respectful submission, he is quite clear. He uses the term legitimate political considerations. Yes. And that therefore raises the question of what are illegitimate political considerations, and how is the court equipped to judge the difference between a legitimate political consideration or an illegitimate political consideration.
It starts, I suppose, by being told what the consideration is.
Absolutely, and I'm going to come on to that in a moment, my Lord, and deal with that in a little detail, if I may. But let us go back to the principles. The Lord President accepts the principle of non-justiciability based upon the subject test. But he says the tipping point is that applies where a decision is based on legitimate political considerations. And I just underline that the court is not equipped to decide what is a legitimate political consideration and what is an illegitimate political consideration. And the matter is not really taken any further by Lord Brodie, where he suggests that the test is one of egregiousness. Again, no judicial standard is being provided. What is egregious in that context? What is shocking to one politician may be very less than shocking to another. Then at paragraph 51 of his opinion, which is at MS 1209, the Lord President sought to rely on what he termed, and I quote, the good governance principle. But again, what is this? If anything, it is a political aspiration. By what legal test do the courts purport to determine what is good as opposed to bad governance? Learned friend Lord Pannick made reference to the case of Bankholt and the Secretary of State, which your lordships can find at MS 2282. I have it in the authorities bundle for this appeal at authority tab 32. I appreciate that these cases appear in more than one place, which is less than convenient, but I hope Milady will bear with me.
The important thing is that they appear at all and that somebody can tell us where to find them.
Well, indeed.
That's the only important thing.
Well, it's helpful if you stick to the bundle for the Inner House appeal, because they're much more easy to deal with.
Well, my difficulty is that in preparing my speaking note, I've had regard to the bundles that I had available to me, and those were the bundles in the Scottish appeal.
Well,
but
that's the helpful one.
Volume 2 in the Miller appeal, tab 23, I think, is Bankholt number 2. That's where we looked at it before.
But in that case, the majority of the court held that the Crown's prerogative power to legislate for peace, order and good government imposed no justiciable limitation on that power. And I would take the court in particular to the judgment of Lord Roger of Earlsferry at paragraph 109, which can be found at MS 2333. And it's in paragraph 109, towards the end of the page. Equally, he says, it cannot be open to the courts to substitute their judgment for that of the Secretary of State advising Her Majesty as what can properly be said to conduce to the peace, order and good government of the IOT. This is simply because such questions are not justiciable. The law cannot resolve them. They are for the determination of the responsible ministers rather than judges. In this respect, the legislation made for the colonies is in the same position as legislation made by Parliament for this country, as the High Court of Australia pointed out. In both cases, the sanction for inappropriate use of the legislative power is political, not judicial. The difference, and it is of course very important, is that orders in council are made without the concurrence of Parliament or of any other representative legislature, and so the political control is less direct. That lack of direct political control over them may well be considered undesirable in today's world. If so, the appropriate remedy is for Parliament, not for the court, to get involved in scrutinising the substance of such orders in council. And again, Lord Carswell, at paragraph 130, MS 2340.
Before we move on from 109, isn't Lord Rogers' point really predicated on what he says at the start of 109? He's making a very technical point about the scope of the powers to legislate for peace, order and good governance in the territory, that being equivalent to a full legislative discretion as Parliament would have.
It's not one which the judges, the courts can test.
No,
it's not
in
just
the same way that we wouldn't test an act of Parliament. That's purely political. But I thought that the case that we're dealing with here is not dealing with an exercise of legislative authority, but of some other prerogative authority, not legislative in character.
Indeed so, but I cite Lord Roger in that context, and in addressing the issue of how, if at all, the courts could address themselves to the matter of good governance, which is the term used by the Lord President in this context.
Yes, thank you.
And to the same effect, essentially, as Lord Carswell, and I'll simply give the reference at paragraph 130C, which can be found at MS 2340. So I submit that although the Lord President and indeed Lord Brodie acknowledge the principle of non-justiciability and its application by reference to subject matter, they simply don't follow through and apply that test which they've identified, but instead slip into concepts of illegitimate purpose, good governance, legitimate or illegitimate political considerations, none of which are amenable, I submit, to determination by the court. But that brings me on to the question raised by Lord Kerr, which is directed to the circumstances in which, in this case, the Inner House felt that they could identify a purpose in respect of the prorogation. And in addressing that matter, it may be helpful just to remind your lordships of the passage which my learned friend Lord Pannick took the court to in Belize. And in particular, the passage that was quoted, I think from Lord Walker's judgment, albeit it may have been a dissenting judgment. And it's found in the case of Das, which he took the court to. I have it at MS 3566.
Sorry, could you give me that reference again, please, the MS number? I
believe I noted it as MS 3566.
In the cherry bundle, is it, or because the cherry bundle goes up to 3171.
It's 1481 in the cherry bundle, I think. If it's Lord Justice Beatson.
Yeah.
Yes.
1481.
Apologise. Sorry, but the Belize judgment in full is produced in the cherry bundle at 2035-27.
Thank you.
Sorry, Lord King, which one do you want us to look at?
Well, I'd be happy to find either of them. So if you'll bear with me for a moment, I will endeavour to do so. Yes, I'm sorry, it's tab 13 in the Scottish bundle, beginning MS 1481 as observed. But going to 3566, which is the internal pagination,
It's 1509 on the MS. It's the final paragraph.
It's the final paragraph, my Lord, is quite right, MS 1509.
Yes, thank you.
And references there made to Lord Walker in Belize Alliance and to the obligation that was referred to cooperate and to make candid disclosure by way of affidavit of the relevant facts and this is the important part in parenthesis, so far as they are not apparent from contemporaneous documents which have been disclosed, the reasoning behind the decision challenged in the judicial review proceedings. And I draw particular attention to the observation, so far as they are not apparent from contemporaneous documents.
Yes, I mean, I see now that this was not the main judgment in which Lord Walker dissented, but it in fact was a preliminary hearing. So I think my point was a bad one.
Now, there was correspondence between the Government Legal Department and the agents acting in Miller on the matter of the production of documents. And if the court has regard to Miller Bundle at page 518, electronically, I believe we had 63. Too difficult for me. If we have regard to the bundle there, we will see the 581, I'm advised. We have a letter from the Government Legal Department of 4th September 2019 to Mishkins.
I'm so sorry, completely my fault. I haven't got the reference.
I have it in the Miller Bundle at page 518.
518. Is that in the second volume? Can you help me? Oh, yes,
I'm afraid if there is an MS number, I don't have it.
Yes, I have it.
Right at the back of the trial bundle.
It is in the trial bundle. It's at the very end of the trial bundle.
Yes, thank you. I have it now.
And in that letter, which was sent in response to correspondence about the witness statement provided in this case and the disclosure that had been given, it said that we are satisfied, having reviewed matters in consequence of that correspondence, that it was properly made clear by GLD that thorough searches were required for information relevant to this claim, and so on. And then towards the end, for the avoidance of doubt, we consider that the reasons for the decision can properly be derived from those contemporaneous documents recording what was communicated to and by the Prime Minister, and especially the Cabinet Minute, and we have seen nothing to suggest that that is not so. Finally, in relation to the redactions made to the documents disclosed, we have nothing to add to the reasons given in the witness statement. We will take whatever steps the court may consider appropriate, remaining as we do concerned to assist the court in whatever way we can, and we have considered and reconsidered the duty of candour. However, our considered view is that both the witness statement and the disclosure exercise have been dealt with properly. So that was the background to how the matter was being approached in that context. And it is then perhaps useful not just to look at the documents that were produced, which quite exceptionally included a Cabinet Minute, but the way in which the Lord President recorded that documentary evidence that was laid before the court in Scotland. And that can be found if we go to the Lord President's opinion, first of all at paragraph 9. Your Lordships have that. There's a heading, the respondent's documents. And it says that on the eve of the hearing before the Lord Ordinary, the respondent produced a number of documents relative to what happened within the government. The first is a memorandum dated 15th August from Nicky de Costa, the Director of Legislative Affairs within the Prime Minister's office, to the Prime Minister. This reads as follows, and if I could just quote from the summary, the current session is the longest since records began, and all bills announced as part of the last Queen's speech have now received royal assent or are paused awaiting carryover into the next session. This makes it increasingly difficult to fill parliamentary time with anything other than general debates. As a new Prime Minister, there is an expectation that you will set out a refreshed domestic programme, and it would be natural to do so when the House returns in the autumn. As the first week's business in September has already been announced, I recommend dedicating the second to wash up on bills such as R&R. We would then prorogue sometime between the end of Monday 9th September and Thursday 12th September, allowing for the long-standing conference recess. I'll return to that point in due course, and return on Monday 14th October with the state opening of Parliament. And then the recommendation, are you content for your PPS to approach the Palace with a request for prorogation to begin with the period Monday 9th September and Thursday 12th September, and for a Queen's speech on Monday 14th October?
Can I just ask, as a matter of information, in the first sentence of the paragraph, where it says that all bills announced as part of the last Queen's speech have either received royal assent or are paused awaiting carryover into the next session.
Yes, at the end of a session, it's possible for bills to be carried over so that they don't fall at the end of the session.
Yes, I appreciate that. So does that mean that the prorogation of Parliament imminently was anticipated?
Well, I think what it means is that at this stage, prorogation of Parliament is being contemplated, because the session of Parliament has run for nearly 2 years.
Yes, I mean, why would you pause a bill to await carryover unless you were anticipating imminent prorogation? I'm just asking.
Simply because if you're at the point where the session is 2 years long, and there's a question of whether or not you're going to go into recess or prorogation, you would consider what you're going to do with the bills. In other words, you would have to take formal steps to carry them over, or they would fall. Can I go on to paragraph 10, where the Lord President quotes under the heading Political Considerations from the same document. Finally, politically, it is essential that Parliament is sitting before and after EU Council. MPs and peers must be in a position to consider what is negotiated and hopefully pass the withdrawal agreement bill. If there is no deal, they need to have an opportunity to hear what you have to say and respond accordingly. And then at paragraph 11, the Lord President, understanding these documents, observed, the memorandum noted that in modern times, prorogation was usually less than 10 days, although there were longer periods for up to 21 days since 1980. Although the planned prorogation would be 34 days, the expected conference recess of 3 weeks would mean that only 1 to 3 days would be lost in the week commencing 9th September and 4 in the week commencing 7th October. There was no record of the House of Commons sitting in late September or early October since the start of the 20th century. I should say that up until 2002, the summer recess of Parliament always extended into October to cover the conference period. In 2002 and 2003, Parliament returned for a period of a few weeks at the beginning of September and then went into conference recess. That practice ceased, but then recommenced in 2010. And since then, as I understand it, Parliament has come back after the summer recess for 2 or 3 weeks at the beginning of September and then gone into the conference recess. And indeed, if we go over to paragraph 12, we can see the note applied by the Prime Minister, and it's in the context of what I've just said. The whole September session is a rigmarole introduced to show the public that MPs were earning their crust. So I don't see anything especially shocking about this proposition. As Nikki notes, it's over the conference season, so that the sitting days lost are actually very few. And then the Lord President went on to consider the further documents, and I'm not going to read them out at length at this stage, but essentially the fourth document was a redacted cabinet minute dated 28th August 2019, was essentially noting what the Prime Minister had decided. And at paragraph 15, the Lord President noted that this said, this timetable gave Parliament ample time to debate Brexit in the period before the October European Council on 17th to 18th October, and again in the run-up to the UK's departure date on 31st October. It was important to emphasise that this decision to prorogue Parliament for a Queen's speech was not driven by Brexit considerations. It was about pursuing an exciting and dynamic legislative programme to take forward the government's agenda. And not surprising that perhaps what was being anticipated there was some pushback for political purposes from other parties within Parliament who might seek to suggest that there was some alternative motive behind the prorogation of Parliament. Now, my learned friend, Lord Pannick, then sought to place considerable stress upon the apparent absence of a witness statement from the Prime Minister.
Lord Keane, if we are leaving the documents produced, do we find in any of the, I think, 4 documents in all, an explanation of why 5 weeks was necessary for the opening of a new session on the Queen's speech?
Yes, my Lord, because it was going to encompass the conference recess period of 3 weeks, with the result that only 7 days would in fact be lost, only 7 sitting days would be lost to Parliament if it was prorogued during that period.
That might be said to be a possible defence to this election of 5 weeks. It doesn't explain why 5 weeks was chosen.
Well, the period of 5 weeks would also fall between the reporting periods under the Northern Ireland Executive Formation Act.
Right, but all of this could be done in 10 days or less, couldn't it?
Not if Parliament is in recess, and I'll come on to explain why that point is significant, and indeed in what respect the Inner House made a fundamental error in assessing these periods when having regard to what would happen and what could not happen during recess, because there was exhibited by their lordships in the Inner House a fundamental misunderstanding of what the position would be pursuant to parliamentary procedure.
Lord Keane, my other question would relate to Ms. da Costa's Spectator article, if you happen to have it at tab 32 of the English trial bundle. 201, I think.
Well, if my Lord would allow me a moment.
Of course. We're told this Spectator article is dated 29 June, and the important headline of Ms. da Costa's piece is, will Parliament be able to stop the next PM leaving without a deal? And obviously one highlights in particular the last sentence of the second paragraph. We've already seen this game played out with prorogation, admittedly a nuclear option. So my question is, would the court be entitled to consider that background when it considers Ms. da Costa's submissions to the Prime Minister in the documents provided?
Well, with respect, my Lord, Mr. Costa wrote that in her capacity as an individual working for a private firm, not as Director of Legislative Affairs at number 10. So it seems to me that it would be perfectly appropriate for her to speculate in her private capacity as to what Parliament could do might do. And indeed, there are other articles referred to by the Lord President at paragraph 7 of his opinion, where it was mooted, for example, in the Daily Telegraph, that if Parliament was prorogued up until or beyond 31st October, then it wouldn't be able to prevent a no-deal Brexit. Now, we know that never happened, and we know that, in fact, Parliament legislated expressly to address the question of our exit from the EU on 31st October without a deal. But I'm sure one could go through any number of media articles, political blogs, and others during this period when a great deal of speculation was going on. But what we are looking at here are the concrete reasons which were given to the Prime Minister and acknowledged by the Prime Minister for the purposes of this prorogation. And in my submission, the documents themselves speak for themselves. They don't require a witness statement, albeit it was contemplated by my learned friend Lord Pannick that this might have given the opportunity for the Prime Minister to be cross-examined upon the matter of prorogation. But having noted that those documents were there, what is perhaps most surprising is the way in which the Inner House departed from the circumstances disclosed in those documents and sought to infer some alternative, sometimes referred to as clandestine, purpose. But before coming on to address that, I should also just notice the point made by the Lord President about the absence or otherwise of a witness statement, because my learned friend Lord Pannick made some placed some considerable weight upon this. If you could turn to paragraph 55 of the Lord President's opinion. He said, thirdly, there is remarkably little said about the reason for prorogation in the respondent's pleadings. Although the court would not expect an affidavit, the Scottish equivalent of a witness statement, from a government minister or official testifying to the reason, and he then refers to the procedure in Belize, Lord Walker delivering the opinion of the minority at paragraph 86, it would expect the averments in the respondent's answer setting out that reason. So it was not the view of the Inner House, Lord Brodie and Lord Drummond-Young say nothing about this, that somehow the absence of an affidavit was of any significance or led to the drawing of any adverse inference whatsoever in the context of the Scottish procedure. And that reflects, as I would suggest, the point made by Lord Walker in the passage in parenthesis, where he says, where the documents speak for themselves, there will be no requirement for a witness statement. And the Lord President, having set out the documents at length, goes on to observe that the court did not require an affidavit in these circumstances. But what the Lord President did was to determine, notwithstanding the terms of the document or documents, that the particular circumstances pointed to a true reason which could then be impugned. That was the term he used, true reason, at paragraph 53 of his opinion at MS 1210. And if I could briefly give the court references to the approach which the Inner House took to this, the Lord President at 56, MS 1211, referred to what he termed the extraordinary length of the prorogation. And he put that in context. He said the extraordinary length, 5 weeks, not 7 days. Lord Brodie referred to the lengthy period of prorogation at paragraph 90, MS 1234. Lord Drummond-Young refers to the same matter at paragraph 122, MS 1252, and said no rational explanation for the length of prorogation had been given. but with the greatest of respect, such an explanation had been provided and is indeed provided for in the documentation and had been recorded by the Lord President in his opinion at paragraph 11. Namely, that because the prorogation would cover the conference recess period, the number of sitting days lost would be up to 7.
Why did it need to cover the conference sitting period?
I'm just going to come on and elaborate upon that, if I may. But the point I make at this stage, how can the court draw an inference of improper motive in the face of that evidence? And that is particularly glaring in circumstances where the Lord Ordinary did not feel that there was any basis for going behind the primary documentation, in circumstances where we know the Divisional Court did not consider that there was any basis for going behind the primary documentation, and where the inner house comes to rely upon inferences which might be contemplated where there's a gap in the evidence, but here there was no gap in the evidence. The inner house conclusion rejects wholesale the documentary evidence that is referred to.
I think you can say that they rejected, but they didn't find, as the Lord President put it, a practical reason for the prorogation. And I'm still hoping that you're going to tell me what it is.
I'm still hoping to get there in just a few moments, my Lord. But the point I make is that a perfectly rational reason having been provided for prorogation, taking into account the conference recess, the inner house seeks to explain it away by emphasising an artificial distinction between prorogation and recess. And this is where the inner house fell into a fundamental error or misunderstanding. At paragraph 96, Lord Drummond-Young, this is MS 1237, observed that if Parliament is in recess but not prorogued, it may reconvene itself. At paragraph 107, lest there be any doubt about this, MS 1243, he said that recess can be revoked by Parliament at any time. At paragraph 119, he said of recess, Parliament can resume sitting at any time. That's MS 1250. And then the Lord President, at paragraph 56 of his opinion, MS 1212, Parliament, when in recess, may recall itself. And then Lord Brady, perhaps a little less explicit, at paragraph 91, MS 1234, said Parliament has a right to sit if it wishes to. My Lords, if Parliament is in recess, it cannot reconvene itself. It cannot revoke recess. It cannot resume at any time. And it cannot recall itself. Standing Order 13, which can be found at tab 33 of the Miller Supplementary Bundle, provides that if the House of Commons is in recess, and for convenience, you'll also find it referred to at paragraph 121 of our written case, because it's summarised there. But Standing Order 13 provides that if the House of Commons is in recess, it can only be recalled at the request of the executive. And then it is for the Speaker of the House of Commons to determine if the executive request is in the national interest. Interesting that the standing orders for the House of Lords are rather different. Standing Order 17 of the House of Lords provides that the Speaker can recall Parliament. Now, there are 2 points to be made here. One, once Parliament went into recess, it wasn't open to Parliament to return at will. And two, if the executive had wanted to prorogue Parliament while it was in recess, it would have had to recall Parliament to prorogue it. And if the Speaker had decided it wasn't in the national interest, that could not have been done. And therefore, prorogation would have been delayed until after the conference recess period, which ran for about 3 weeks, into and including the first week of October. So once you factor in that point and appreciate the fundamental misunderstanding or error made by the inner house, you can go back to what the Lord President said at paragraph 11 of his opinion. In summarizing the documents that were before him. That's at MS 1190. And this is the Lord President recording the documents before him. Second line, although the planned prorogation will be 34 days, the expected conference recess of 3 weeks would mean that only 1 to 3 days would be lost in the week commencing 9th September and 4 in the week commencing 7th October. A total of 7 days. And yet, later in his opinion, he expresses his opinion about the extraordinary length of the prorogation on the basis that it's 5 weeks rather than 7 days. It was in reality 7 sitting days that were going to be lost, not 5 weeks of sitting days. And that, in response to the inquiry from the Lord Kerr, is
why lose even 7 days? What is the practical reason? That's what the Lord President poses.
With respect, that is not the question the Lord President poses at all. He poses the question of why they've lost 5 weeks instead of 7 days.
Well, let's suppose it is 7 days. Why lose 7?
Why should it not be 7? Why should it be 1 day? Why should it be 14 days? How is the court going to judge what is an appropriate period for a prorogation determined by the executive in exercise of the royal prerogative?
Is there anything in the documents which is directed specifically to the reason that any days, whatever, should be lost?
I've taken your lordship to the documents. The point that the Lord President relies upon is that 5 weeks have been lost instead of 7 days. It is perfectly clear, once you understand how recess operates, that there was no loss of 5 weeks of sitting time for Parliament. There was a loss of a maximum of 7 sitting days.
Can you help me with some really basic practical questions? Could Parliament have decided not to go into recess?
Theoretically, yes, although there was no record of it not being in recess during this period since the beginning of the 20th century.
But the theory is it could have decided not to, in which case
recess, yes.
The number of days lost would have been the larger number that we've been looking at.
If it had decided not to go into recess. But as I say, there was no record of it not having done so.
Second question, really practical question. Could it have been a prorogation from the date after they came back from the recess? Would that have, that would still have worked, wouldn't it, in terms of
They would have had to wait until it had returned. It was contemplated that its return would be after the first week in October, so you would go into prorogation, and even if you limited the prorogation to a few days, you'd be returning on about the 14th of October, which is the end date of the prorogation that was actually granted.
But it could have been a prorogation from that later date and still achieved the 14th of October.
It could still have achieved the 14th of October, but Parliament would have been in recess for the preceding 3 weeks. Well, let me be careful. The House of Commons would have been in recess.
Yes, the House of Commons and the House of Lords don't go into recess at the same times, necessarily.
They sometimes
they do and sometimes they don't.
But they don't necessarily coincide. And if, for example, the House of Commons decided not to go into the conference recess, but the House of Lords did, Parliament couldn't pass primary legislation anyway.
No, but the committees would be able to continue.
Well, the committees can function during recess. To what extent they do when people are away at parliamentary conferences may be an issue of fact, but they could, and written questions could be submitted during recess. But
Thank you very much indeed.
Those are both important forms of accountability.
They are forms of accountability, but given the speed with which the committees operate, I question whether, during a period of 3 or 4 weeks, one was going to see a startling change in the operation of a committee.
But questions would be...
Well, questions could be submitted, written questions could be submitted, and we would be responded to in writing. But that's the extent of it during recess. But the point I make is that it is quite plain that the inner house, in addressing this issue and deciding that it could impugn the decision of the Prime Minister, was proceeding upon a fundamental misconception about how Parliament operated.
Given the importance of this, I'm not sure it's... Well, it's striking that Mr. Costa's minute refers to a number of considerations bearing on timing, and indeed gives an explanation of a kind that I think Lord Kerr may be looking for, which aren't referred to in the Lord President's opinion.
No.
I mean, for example, she advises the Prime Minister against having the Queen's speech a week earlier on the 7th of October because key votes because of the SNP conference. And she gives an explanation about proroguing in the period of the 9th to the 12th of September to do with the practicalities of wash-up of the existing bills.
In addition, she says at paragraph 10, with regard to the date for the Queen's speech, number 10 and the legislative-focused parts of Whitehall and the business managers have long had a mid-October date in the diary, and it has been a central planning assumption. However, additional work now needs to be undertaken so that the Queen's speech is shaped to your domestic priorities. In my view, the week commencing 14th October is achievable, but any earlier is extremely pressured. And then, on a lesser note, a Queen's speech on 7th October will place key votes on the days of the SNP conference. And then at 14, finally, politically, it's essential that Parliament is sitting before and after the EU Council, and that's a passage I referred to before. So there is a detailed analysis with respect to why the prorogation, standing the conference recess, should take us up to the 14th of October, although in theory, I accept the observation made by your ladyship that you could have come back at the end of a conference period after the first week of October and sort of a Queen's speech and then prorogue Parliament. But there are a variety of reasons given as to why that would not be considered appropriate.
You know, people will have to read it, but there is quite a lot in this minute to do with reasons for the timing advice that was given.
And yet all of it is cast aside by the inner house in place of an inference, which isn't required because the documents speak for themselves, and in circumstances where they didn't consider it necessary that there should be any additional affidavit or witness statement to speak to the documents, which were plain on their face for the reasons that we've just considered.
And yet, I've mislaid where Mr. Costa's memo is. Could you please remind me? I'm sorry.
I believe it's 317 in the Miller bundle.
317.
In the trial bundle. And electronically, if you've got the Miller memory stick, which I haven't.
Yes, thank you.
381, MS 381.
I was looking for it in that bundle, but I mislaid it. Thank you so much.
I would just add, because the question of Parliament voting against a conference recess was raised, or not having a conference recess. That's a matter of fact that was not explored. I do notice that there are a number of members of Parliament who are parties to the Scottish action, and the first petitioner provided 3 affidavits on various dates. The first, very detailed, the second dealing more with the issue of costs, and the third dealing in some detail about the issue of interim relief. And having examined those affidavits, I can find no hint or suggestion that Parliament would not have gone into conference recess. And yet, Lord Brodie was able, he felt, to describe the period as egregious. The Lord President was able to describe it as extraordinary, but only because, as I say, of a fundamental misunderstanding of how Parliament operated in the context of recess. My Lords, given the time, I would seek to rest my submissions there. In my respectful submission, it is appropriate that the interlocutor of the Inner House should be recalled. And in any event, even if the court were to be against me on that, I would submit that it should recall part 4 of the interlocutor for the reasons which I sought to give earlier. And having noted what Lady Hale said about trying to agree a form of words for an undertaking, I will speak to my learned friend, Lord Plannock, on that topic. And see if
and
we
no
can
doubt to
produce
those instructing you.
I don't think Mr. O'Neill is ever readily ignored in these circumstances. You may rest assured on that point. Unless there are any further questions from the court, I would rest my submission. I'm most obliged.
Thank you very much indeed, Lord Keane. Mr. Webster? Well, with congratulations to everybody for the precision of their timing, the court will now adjourn and look forward to hearing from you, Sir James, tomorrow morning at 10:30.
way he is. I think he's what, sorry? Sorry, it's really loud here.
Very calming call. Experience. Really is unusual to see three calls. not necessarily start right, but people start to get
Yeah, was that again a pretty question? How would you say things are going for you today?